Morning, ladies and gentlemen. I hope you had a restful sleep. I hope you're ready for what we have to offer today. It's going to be a very engaging discussion today. Your moderator for the day is Paul Winnie Kasami. I am an associate at LegalMark Advocates, and I am currently in the Insolvency and Business Restructuring Department. We have a number of topics, very interesting topics lined up for you today and also tomorrow. This is the 2023 Insolvency Conference by the Uganda Law Society and LegalMark Advocates. And for today, we are going to be having, we have with us Mr. Isaac Atukunda, the Uganda Law Society Secretary, who will be giving us the opening remarks, and then we jump right into it. Welcome, Mr. Isaac Atukunda.
Thank you, the moderator. Good morning.
Good morning.
Thank you, the facilitators of today's conference, the speakers, and our members attending the conference online. First of all, I would like to thank LegalMark for having offered to host us. That's a very good gesture, and we request other members of Uganda Society to offer the same whenever we have conferences. I bring you greetings from the President of the Uganda Law Society and the Council. They send greetings to all the members who are attending the conference online. I know I'm not able to say much about the conference because most of our moderators or speakers are experts in the field. But I would want to use a quotation from Ruben Hinojasa. He said that high bankruptcy rates, increased credit card debt, and identity theft make it imperative that all of us take an active role in providing financial and economic education during all the stages of one's life. So it means that it is imperative for us all to have knowledge about insolvency. So I cannot in any way underscore the relevance of this conference, and especially for our practitioners who major in insolvency practice. I remember I had a matter to do with insolvency. I had to call upon one of our members and offered him the work because I lacked knowledge about the subject. So it is my feeling that at the end of this conference, as practitioners, we should be able to know what insolvency is all about, what insolvency practice entails, what is expected of an insolvency practitioner, and the practical world of insolvency. For example, you'll find most of us covered insolvency in our law schools, but when it comes to application of the principle in the practical world, it's always a bit hard. So by the end of this conference, I would expect us to have this knowledge, because as part of Uganda Law Society mandate under Section 3B of the Uganda Law Society Act, one of the core mandate of Uganda Law Society is to facilitate acquisition of legal knowledge to its members. And that's one of the reasons we always organize these conferences. So I really want to thank our cluster, the insolvency cluster, which is headed by senior lawyer Kalamaji. I know it has done a lot to facilitate this conference. Otherwise, with that, I wish you nice deliberations. I'm looking forward to also acquiring this knowledge so that at the end of the day, I will be able to say, wow, it was worth organizing it. Last, I call upon all the members who are attending the conference online to make sure that they partake in our extraordinary general meeting, which is coming up on the 18th of August, where we shall be addressing matters relating to members' welfare. It's an extraordinary general meeting that will be talking about the healthcare and benevolent fund, because as council, we feel that besides acquisition of legal knowledge, which is through CLEs, we should also be concerned about our members' welfare. So I call upon members who are attending the conference also attend our extraordinary general meeting, and they give us their views about the fund, and also we call upon them to join in the fund if we get approval from the membership. Thank you very much. Nice deliberations.
Thank you so much, Isaac, for the very detailed introduction of the program. And we hope that we've picked a thing or two from his introduction. At least one thing that we are certain of, or we are certain about, is that throughout this conference, we are going to engage in the provision of financial and economic education for all. And that is why the panel that has been lined up, the speakers that have been lined up, are really taking it upon themselves to extend quality education in as far as insolvency services in the country are concerned. And who better to kickstart this than the man himself, the chairperson of the cluster, Mr. Kabito Karamagi, who is going to be taking us through a very, very interesting presentation today. So just a brief about our speakers, about our speaker. Most of you already know him. But as you can see, Kabito Karamagi is an advocate with 23 years of experience and specializes in corporate insolvency, business restructuring, and restructures. Kabito is a fellow of the INSOL International, a global association of insolvency practitioners. He is also Uganda's leading insolvency practitioner and has been at the center of major legislative reforms related to insolvency, most notable the formulation of the Insolvency Act of 2011, which happens to be Uganda's first consolidated insolvency code, together with debt restructures and turnarounds. Currently, Kabito is the managing partner of LegalMark Advocates, and he is the head of the insolvency and business restructuring practice at the firm. Kabito is a seasoned and respected litigator. His wide experience includes representing financial institutions in creditor enforcement claims. He serves serving as lead counsel in a consortium of lawyers and successfully representing the electricity regulator in the biggest regulatory dispute in Uganda. That is to mention but a few. So at this juncture, I invite Kabito Karamagi to take us through a very interesting topic regarding the interim protective orders and what exactly happens behind the scenes. Mr. Kabito, we welcome you.
Thank you very much, Paul. Good morning. Good morning, all of you members out there online. I'm pleased and honored to come before you today to make this presentation. Interim protective orders for corporate insolvency, behind the scenes practical approach. In respect of this topic, I thought it wise to make reference to a case we're handling, a live case. Sorry, how does this work? Pardon me. Okay. A case that we are presently handling, and I'm going to use the experience from that particular case to help us in this discussion. But now, to begin, let's just understand what corporate rescue is really all about, and why we use interim protection orders and what they serve to achieve. These two cases that I'm sure you can see on the screen, I think give us a very good starting point to contextualize what interim protection orders are all about. Interim protection orders are meant to facilitate the rescue of a company, corporate rescue, financial, a business rescue, business resuscitation. So looking at the case of Southern Palace Investments, just look at what the judge says there. It is difficult to conceive a rescue plan that will have reasonable prospect of success of a company concerned on a solvent basis unless it addresses the cause of the demise or failure of the company's business and offers a remedy, therefore, that has a reasonable prospect of being sustainable. The next, a quote, let's read it together. Business rescue proceedings are not for terminally ill corporations, nor are they for chronically ill. They are for ailing corporations, which given time will be rescued and become solvent. So, as you can see, the opinions of those two courts are imperative to put this into context, this discussion into context. We are not dealing with terminally ill or, so to speak, dead corporations. We are dealing with entities that are ill. So, it is important for a company that is experiencing a decline to address the root causes, and I underline the word root causes of its problems, for it to be resuscitated. I always give the common example of having a toothache. A simple toothache that grows in time. If you don't go to the dentist sooner or later, you'll get that knockout pain, and even a root canal will not be able to help you. And just as well, if you have a cancer and you're not treating it, the day you're wheeled into the emergency room, a doctor there will have to make a call. Should I take you to the ICU? For how long will you be there? Or do we keep you here until... Are we on?
Recording in progress.
Screen. Sorry, we've had a glitch. I can't see the screen. Okay, I'm managing this. Right, we can proceed now. And the case I want to talk about, to protect, because this is still a live case and to protect the people involved in it, I've just called it the GLC case. It's a reported, not a reported case, but it was filed case. And it's fairly public, but nonetheless, I still think that I should take measures to protect the people involved, but it does offer a lot of things for us to learn from. So GLC is a very interesting company. It took out several loan facilities from a bank we call Bank One for several years, about 20 years. They had a relationship with Bank One for about 25 years, and over time, it took out facilities from this institution, secured those facilities with debentures and stock assignment deeds. This company, GLC, later took out facilities from another bank I call Bank Two, that it secured with a second ranking debenture and also gave a fixed charge. Of course, as it grew in business, it took out more facilities, but particularly from what we call a group of agribusiness development lenders that they gave stock assignment deeds as security. A lot of this was this credit was really revolving in nature. Funds were availed to the company. The company then bought stock from farmers. It processed the stock, sold them to off-takers, and then from that it was able to pay the lender. So it was a very simple transaction. So GLC later defaulted on repayment of its facilities, upon which Bank One, during engagements with its stakeholders, learned that the receivables from sold stock assigned had been diverted. Also learned of several other falsehoods, declarations made to the company by the directors. But also of great concern, just as great concern, was that GLC was actually indebted to far more financial entities that it had disclosed. At least 3 local banks were involved. They had also financed purchase of stock, and the stock was nowhere to be seen. So after some consideration, Bank One decided to enforce its rights in the debentures, appointed administrative receivers. But here is a bit something different. It enforced not so much for the purpose of liquidation, but for the purpose of sustaining the company. So the approach that the Bank One had in mind was to use a receivership and resuscitate the company. So it thought that it could do that by getting on board a coalition, creating a coalition of the company's lenders and a few stakeholders to try and see how they can support GLC. Now, for either reasons that GLC was unaware or perhaps distrustful of the bank's intention, what it did was quickly run to court and get an interim protection order to commence a professional administration. The court pleadings clearly show that GLC wanted an interim protection order to enter into an scheme of arrangement with its creditors. However, no application for a scheme of arrangement was filed, and it later became very clear that there was no intention for a scheme of arrangement. We'll be discussing this a little later to see how that can cause a confusion. The provisional administrators who were appointed over the company commenced their work, and they had several meetings with the local banks and the agribusiness lenders, and somehow, I guess they convinced them that they had a good deal, so everybody abandoned Bank One's coalition, believing that the administration of the company offered a better value for their positions, especially as unsecured lenders. The provisional administrators held a couple of meetings with the Bank 2, the other secured lender, but the engagements with Bank One were really lukewarm. In fact, it would be fair to say maybe hostile. Now, later on, and this is long after the interim protection order had been given, the provisional administrators come up with a plan which they share with the local banks and Bank 2. But that was just before the lapse of the administration. Now, Bank 1 and Bank 2, being the secured lenders, decide to oppose the administration the plan itself wasn't really a plan, so to speak. It kind of was saying this is where we stand. In fact, let's call it, in all truth, it was a provisional administrator's report of the company. But administrators were asking for more time. They're clearly going to ask for more time to come up with a plan. So the secured lenders decided to oppose this at the creditors' meeting. And clearly the provisional administrators had done well in their canvassing efforts. When put to the vote, the creditors agreed to give the provisional administration a chance and authorized the provisional administrator to go to court and seek a formal extension of the administration. So at the vote, the two secured lenders are the only ones that voted against the extension. However, they decided to go to court and oppose the application for the extension. And so, after hearing the submissions, court decided to grant the provisional administrators the request. But in so doing, it actually added the provisional administrators more time. So roughly 45 days or so, because of the hearing schedule and the time to write a ruling. So the provisional administrators got a lot more than they had asked for. At the end of the second extension, it also became apparent that the provisional administrators did not have a plan and could not devise a plan to resuscitate this company. And so the secured lenders this time secured the support of the agro-business lenders to end this provisional administration. So at the second general meeting of creditors, the rest of the voters, so the rest of the creditors, the unsecured lenders and so on, voted to continue with the provisional administration, but the secured lenders and the agribusiness lenders voted to end it. Since they had the numerical strength at that point, the value of the company, they took the vote. And by doing that, then the company reverted to the back to the receivership. However, this time the secured lenders were not in a good mood to resuscitate the company. They withdrew their offer of support for the company's resuscitation through the receivership, basically leaving little option for the receivers other than to liquidate the company's assets. However, the secured creditors accommodated a request from the company GLC, which reached out to them and asked them for some time to arrange for a refinancing of the facilities and see how they could rearrange their business. So the banks gave some kind of limited concessions to that effect. So that was GLC now really out of options, but going back to the secured lenders that they had run away from. So equally out of option were the local lenders who, having abandoned Bank 1 and Bank 2, jumped on their company's bandwagon, and now really at the mercy of the company's efforts to recapitalize its business. So if that doesn't materialize, they have suffered a loss. They will suffer a loss. Now, even in its sleeping state, GLC continues to be quite a respected player in its agribusiness space. The agribusiness, it's a processor and manufacturer with a strong brand that it has established over the last 25 years, thereabout. GLC credits Bank 1 for its growth. 25 years ago, when its directors came into the country literally penniless and started the company, Bank 1 took a chance on them and gave them $100,000 that formed their first facility. And year on year, they have taken facilities out of Bank 1 and grown to the empire that they are today. So they have a very special bond. They did not have any problem over that period until somewhere about 12 months ago, when Bank 1 discovered GLC's falsehoods and misrepresentations. And by the way, it's also the first time really they're defaulting. The two directors I talked about are now of advanced age. About 4 years ago, they resigned. They retired from actively running the company and handed over management to their sons. So those are the ones who are managing this today, and it's under their watch that we are seeing these problems. Now, the very first trouble we see with this, some lessons we could take, we'll see. Remember, we said that the petition that was filed by the company clearly stated that the company sought an interim protection order so that it could enter into a scheme of arrangement with its creditors. And as it later turned out to be, that wasn't what happened. No application for a scheme of arrangement was filed, and no scheme of any sort was presented. So that for us was the first sign of trouble. There seems to be a misunderstanding of what these two processes are: schemes of arrangements and administration. Schemes of arrangements are different processes and managed under the Companies Act. Administration is another corporate rescue process under the Insolvency Act. The scheme of arrangement is not necessarily is open to companies that are not necessarily in financial distress. Scheme of arrangement under our law, sections 234 to 236 is generally they're called compromises, arrangements and compromises. So that's I may use that and confuse you, some of you. What we call them under our law, sections 234 to 236, is arrangements and compromises. But what they are called globally as called schemes of arrangement. The scheme of arrangement allows a company that seeks to enter into an arrangement with its creditors or its members or a section of its creditors. I'll say that again. Its members, all its creditors, or just a section of those creditors. It allows the company to file an application to court to sanction a meeting, for the company to call a meeting of the creditors, present that compromise, and if they agree, then they can go back to court and have that agreement sanctioned. So the process here is a very, very simple process. The company proposing a compromise, applies to court to sanction for a creditors meeting. The court sanctioning that meeting gives conditions on how that meeting should be held, including communication, date of meeting, and so on and so forth. The notices are sent out in the manner ordered by court. The company then holds the meeting. That meeting is going to be in classes. A class is defined generally as a group of creditors that are likely to be together by common economic factors. The most common of classes we have are the unsecured and secured classes. Secured and unsecured. Those are likely then to vote, to have a common economic factor, and then they vote together as secured lenders. Now for the unsecured lenders, that's probably too broad. You can have maybe employees who have not yet been paid. So those may have their own class. You may have trade creditors who may also form their own class, because there can be a bank that is unsecured, but it's not a trade creditor, so it's going to vote differently. So the idea is to put the groupings of creditors according to their economic interests. Now, back to what the scheme of arrangement achieves to do is that it gives the affected class of creditors or members an opportunity to vote on that compromise. A vote is attained at 75% of the value, 75%, where it is voted on and passed, the compromise voted on and passed. The company then goes back to court for what is called a fairness hearing. This is when those that might have felt aggrieved by the decision can make petitions to court on whether or not this should be sanctioned. This compromise should be sanctioned. When it is sanctioned, and then of course after that the compromise binds all the creditors, whether they signed or not. So that's the compromise. The administration, on the other hand, affects all creditors. All creditors. It rarely affects, in fact, it doesn't affect members of the company, shareholders. However, even though these two are distinct, it is possible to apply to court for an interim protective order and use a scheme of arrangement as a restructuring tool. That could be used, for example, if you want to offer a specific deal to a class of creditors. So you scheme them. It's possible. But when you do that, when you file for the interim protection order, just as well you need to file an application for to sanction a creditors meeting for that purpose. In both cases, you need to have the plans ready. What do you want to do? The Insolvency Act says you are calling this meeting to put forward a proposal or a plan, a settlement plan to creditors. So for any court that should ask, the question is, where is that plan? And that forms the discussion for the troubleshooting issue we have in number 2. In this particular case, GLC, the plan that what they called a plan on review and scrutiny, was really a PowerPoint investor pitch, giving very little about the company's history, about the company's performance, and more about the industry and what it needed to do to grow its business. So it was just a pitch. We need $8 million to do this and that and the other, but it was a pitch, a pitch. So even if we needed a compromise, that PowerPoint presentation did not pass for a compromise under Section 234 of the Companies Act to qualify for a scheme of arrangement. So those were the immediate signs of trouble when we noticed that, when we studied that application. Then during the provisional administration, something became very, very clear. There were deliberate efforts to hold off the secured lenders, particularly for Bank One that was taking the lead in this enforcement. They were denied information. Of course, the whole purpose of getting the interim protection order was to frustrate the enforcement. It was a knee-jerk reaction. And so as the narrative I have given you showed, the plan that was supposedly made after and shared with the lenders, came down to Bank One, which was taking the lead on the enforcement, much, much later. No engagement, lukewarm support, lukewarm reach out. It did look like there was a deliberate effort to hand off Bank One. And indeed, during the meetings, the creditors' meetings, it was also apparent that the interests of the secured lenders had been weaponized and were used as some kind of a boogeyman to hold the unsecured lenders to galvanize for the support of the unsecured lenders. The narrative was, the bank is going to sell, you're going to lose. Is that what you want? What's the answer? No. So how should we vote? More time. That was the narrative. And perhaps, unfortunately for the local banks who should know better, they too fell for the trick. Now, leading this, unfortunately, were the provisional administrators who, I think, in my opinion, had misplaced loyalties. A lot of the decisions they made were lacked the requisite partiality. And there was, at some point, became very clear there was going to be a coalition course between the secured lenders and the provisional administrators, who were clearly working or perceived to work under the influence of the company's management. The immediate lessons we draw from this case that I think we should discuss now, and that this will then inform the discussion, the next part of the discussion of what are those things, the behind the scenes practical approaches we should have towards handling the interim protection, application of interim protection orders. So the first, and broadly speaking, we probably need to set up some kind of evaluation process. When these matters come before court needs to set up some sort of standard. My first observation is that interim protection orders were kind of sought for or obtained in the manner that we get an injunction or interim orders. Unfortunately, interim protection orders and interim injunctions, orders and injunctions, serve different purposes. Interim orders and interim injunctions preserve a status quo. They are meant to preserve a status quo. Secondly, they are orders given against individuals that are parties to the suit. Interim protection orders serve a different purpose. IPOs, first of all, can reverse a status quo. Because once an order is given, it has an import of not only freezing, but suspending certain rights. If there have been enforcements, those rights stop. If there has been a distress, it stays right there. The provisional administrator takes over from there. Secondly, interim protection orders apply to a whole body of creditors. Everyone. You don't have to be a party. As long as you have a claim, stay where you are. Now, if the interim protection orders have that far-reaching consequence, yet interim orders and injunctions affect only the individual rights of the parties in a suit. Isn't it interesting that the case of interim injunctions have conditions for which this relief can be given, but interim protection orders that have far wider implications don't have? So we need to address that we need to create some objective criteria for granting IPOs and their extensions. We need to set standards. The way we have the conditions for granting of an interim, a temporary injunction, as we know them, there must be a status quo to protect. There must be reparable damage to suffer. Those ones, as balance of convenience and so on. We need to set something for IPOs as well, knowing well that in this case we are dealing not just with one individual or two or three, but a whole body of creditors for the interests of one company, one debtor. We do that. We need to balance these interests. There is the secured lender. The secured lenders who have purchased, who have literally, quote unquote, paid cash for that preferred position. They have given out their money or advanced a facility or credit on the basis of an assurance that in any state of insolvency, their interest will be treated first. So there is need for us to set that objective criteria, which seems to be lacking. The observation I had is that the courts were giving these orders as a matter of course, just like you would an injunction and an interim order. The bank wants to do this, oh dear, quickly, let's do this. Even where statutory requirements for the order were for the filing are there, have not been met. For example, in this particular case, the company had not audited its accounts for a couple of years. So the requirement, of course, is that you give a list of assets and liabilities. Those are normally within their books, and then if they're not there, so the question that you should think that the company, the application is failed for failure to comply with to provide the necessary information. Now, if you don't do that, you should expect that should fail. But here the courts were simply giving this. I don't think the courts really understood or are yet to understand the implications of the IPO. More the need for us then to have some kind of objective criteria. Now, talking about just the IPO, I need now to talk about how even it's extended. The law says, Section 143 says that an extension should be given in exceptional circumstances. The courts have defined what exceptional circumstances are. It's something unusual. In one case, a ruling by Justice Mubiru, Honorable Achire versus Okumu Renga, I believe. Regan Okumu, one of those. He says this is not even a matter of judicial interpretation. It's a matter of fact. What's unusual? Tell us what this unusual thing is, and then we can determine whether to give it to you or not. The problem is, we don't have that when it comes to insolvency. Should we adopt that? Can we define what exceptional circumstances? The nature of the law here was to ask, in any event, ask whoever is applying for this extension to give really good ground. Because of the nature of the implications of the IPO. So we believe the courts should be able, it should be the first guard to interrogate whether someone should qualify for this, to interrogate a plan, to interrogate this historical data. If they're giving you, if the law requires that you are given this list of financials, the expectation is that it's going to be useful in your review. So review, but to what end? So we need some sort of criteria, objective criteria to be set. The other issue that comes is what amounts to a plan or a proposal. The law doesn't really define that. But in all fairness, can a PowerPoint presentation amount to a plan? Can it? The plan should speak to creditors' needs. Something like that. So a lot of what we're going to talk about is related to this in the next phase of our discussion. The fourth issue we noted, and the lesson, something to think about, is how to better protect the secured lender's rights. Can a provisional administrator just ignore the rights of position of a secured lender? Shouldn't there be some sanction? If the secured lender says, I want to look at my stock, I am coming tomorrow to look at it, should the provisional administrator write to all the other lenders and say, by the way, we are organizing a meeting for everyone to come and look at assets. You come with this secured lender. Does that even sound right to you? With the other laws, insolvency laws out there, the remedy of an interim protection is not available to the company unless the secured lender has sanctioned it or is somehow involved. Our law doesn't seem to allow that. So what do we do? Because how do we protect that position that he has paid for, that he is going to be preferred his rights will be preferred at that point. Should court summon him and get his buy-in? Should he be heard on the application? How can we ensure that the secured lender's opinion is respected, even though he has not been involved in the appointment of this of the provision administrator? Related to that are the relationship between these two. There probably will need some sort of legislative framework about this, but maybe the courts can help us. We need to create the law as we work together. Lastly, the law is interesting. It provided for a transition from provision administration to administration, from provision administration to liquidation. It never provided for transition from provision administration to back to a receivership. So in that case, you have questions to ask. What kind of information does a provision administrator give to a receiver? How does he hand over? In this particular case, for example, we found a lot of course, the provision administrator incurred costs during his management, rent, and so on and so on. They are unpaid. Is that a responsibility for the receivership that did not take benefit of the provision administration? Remember that those costs eat into the secured lender's interests. So if this administration, for example, had taken 3 months and incurred an extra, say, $100,000, didn't pay, that $100,000 now has to be paid by who? The receiver? The entire expense passes on to the receivership? So there are gray areas that we notice there that we have to think about. But now to the main topic. To the main topic of our discussion, the behind the scenes. Now that we have some understanding of the GLC case, the lessons that were drawn for it, what can we do? What are those things that we need to do? First of all, let's focus again. It's point to go back to where we need to be. Business rescue is for companies that are not terminally ill. And for it to be successful, we must deal with the root cause of its sickness. I beg that you remember this consistently. It's not for terminally ill corporations or chronically ill. It won't help, because the intervention there needed in those cases is much harder and can not be reasonably, will be rarely be achieved in the context of an IPO. So what is then the proper roadmap to the IPO? There are essentially 3 stages, or maybe 4. Number 1, conduct a review of the business. Review. Come up with some plan. What do you need to do? It's there. Have it. Then, how does that plan affect key stakeholders and creditors? Key stakeholders can be suppliers. Key suppliers. You can't switch from one to another. How does what you are contemplating affect those rights? And what are they likely to do? Then engage them. Have a one-on-one with them. Sometimes not in office. Have coffee. Be vulnerable. Get some feedback. Go back, incorporate it in your plan. Now then go make a formal plan. Engage them. At least on the things that they agree. Put them into your plan. Do your stakeholder mapping fairly well. Then go to court. Those three. Those are the three. So, what are these things behind the scenes in more detail? When you're doing your business review, look to the past and the present. Take the time to study the business history and assess, first of all, how bad is this crisis? Is it only a cash crisis? Cash is that you don't have the money now, but maybe it's out there. It's out there. You don't have the money to pay creditors or people. You're getting all these letters that are coming in and asking you to pay. You're getting summons and so on, but you have money stuck in real assets, in bonds and stock. Is that something you can liquidate quickly? How do we get here? Understand, how do we get here? Did someone resign? Someone competent resign and go 3 years ago? That's why you need to study this history and see where does the curve start going down. Where does this curve start falling? In terms of profitability, performance, look at things like staff turnover. Those are some of the key indicators. Sales drops. When did you last do a marketing campaign? Research and development. Those, study the business. Study the market. What's happening? Is competition? Is there new competition? Increased competition? Is it easier to enter the industry now? Change of law, maybe tax, technology. We are not investing in technology. What's the problem? Have we borrowed money that we are not, there's a mismatch between our business and the money we're borrowing? We're earning in shillings, but we're borrowed in dollars. So you see how that just already is a mismatch. We've borrowed short-term financing to fund a developmental project. That's a mismatch. You're going to have a problem there. So what are those things that are causing this crisis? What can we do to reverse? So the key purpose of this review is to understand the underlying causes of the decline. I say it again, underlying causes of the decline. So now that you know how the company has performed in the last couple of years, 5 to 10 years, what it was doing right, what your espionage activities or intel is telling you about the competition and so on. Now look to the future. What's happening? Is this a good business anyway? What does the future look like? If it's a good, what do you need to do to turn around this? Now, then you do your forecasts. Identify the measures you need to put in place and the forecasts. And it could be just as simple as retiring people. There is a certain company around town that tried to come back into town. It was apparently a big deal in the 60s and 70s. But when the owner came back to start it, he just got back all his old boys who are not 20 and 30 anymore. Tastes had changed. No one could wear his shirts on the market anymore. Closure. So things like that. Do your focus. If you want to get rid of some old people, some retired people, or to bring in new tastes, do it. Then understand what you need to do about those, because those may be terminal benefits. They could be about benefits of retiring early and so on. What is that? It has to be financed. Find it. But if you get new people, identify those. Who are they? What are they going to do? How much are you going to pay them? What will they bring? That then speaks to the future. But if you're doing that, you're really following the criteria: preserving the business, maximizing value for the interest of creditors, preventing staff redundancies, especially where the staff are good. Where the staff are good. If it's an issue of culture, because people come in late, they come at 10 in the morning, the boss comes in at 9, really work starts at midday because people have breakfast, then eat, then newspapers, So if it's a culture, maybe all you need to do is just bring in a new HR or engage activities that improve on the productivity, that sort of thing. So you want, if you're looking at bringing in new technology, then where is that money going to come from? Who is going to finance this? Are you going to have an exit? Is there somebody that is going to, a new partner you want to bring on board in the business so that he can avail this money? But if you do bring it, the key answer is how then does that affect on the future, on the projections? So you have to do the financials. So now that you've looked at the past, you've looked at the future, and this is what you want to achieve, you looked at the state and you see what you need, craft your proposals. That's when you start doing your plan. Again, you're looking at the causes, not the symptoms. Don't treat the fever. The fever is just a symptom. Find the cause. Now, be realistic with what you have. It's got to be realistic. If the measures you have are, if you are trying to bring about are not achievable, then perhaps it's not time for a rescue. It's not time to rescue. You have to think of other options. Wind down the business, maybe. Or scale down and see, redirect it to something else. I don't know. Yeah, that's the way it works. You have to think this through. Number 4, during this time, there is always a temptation to divert assets, to borrow more, and so on. There's always, that panic button pressed. We urge that you please advise your clients to act responsibly, not gamble. This is a time to think very, very, very clearly. The answers are always there. Do not make the situation worse, particularly for the creditors, because now it's likely that within a year or two, that company will be in some sort of formal insolvency proceedings. And then all these borrowings are going to be then set aside for one reason or another. You thought that you needed money quickly, you took it on whatever terms you wanted, then suddenly you have that loan set aside, and then that bank possibly coming for you personally. You are selling you're selling an expensive asset cheap, and down the road, because you want to deal with something serious, an emergency before you, but then that is an undersell value. So those things may be set aside, leaving you in worse problems. So act responsibly, try to remain clear to your client, guide them properly, and have the long view, take the long view of things. So now with your plan, with your draft plan, some draft plan, you have an idea of what you want to do. Go on a charm offensive. Know who to charm. Create a communication strategy. A communication strategy that tells you, number 1, who to talk to and what to say. The kind of communication you're going to have with the banks, whether secured or unsecured, is very different from that you're going to have with your suppliers. And some of the things are as simple as saying, can you reduce our credit term? Can you improve on our credit terms? Give us, we are obliged to pay you every 30 days. Can you make it 60 days? It's simple things like that to help free up your cash. But it's a charm offense you must have. Now, obviously, by this stage, word is already out that you're finding some trouble. So just as well, depending on the organization you are, you want to manage the media? Do you want instead to engage with specific influencers if speaking of influencers, and I was talking about influencers in the credit space, but just as well, now we are in the real world of social media. You want to see what you can do about that, because you see, the thing is that it's the next stage is to go to court, to go public. So you need to position yourself ready to manage the negative comments that may come out of your action. You have to take control of this narrative. So how do you test your plan? I said this is going to be largely about how to create a plan and how to have a viable plan. At the base of your plan are two things: your current realities. What is the reality? I can't get that money until next week. I can't get this. I can probably do that. I can't the other. That's on the one hand. On the other are creditor expectations. Every creditor is going to be in that room asking himself one question: WIT FM, what is in it for me? The way you answer those questions is informed by the key considerations you must have as you prepare this plan. First of all, does the plan address the main reasons for the current cash flow difficulties? The underlying cause. Do I have, first of all, do I have it right? So you've got to be accurate about identifying that underlying problem, and then address it. Number two, does that plan offer a clear and realistic strategy for the business to move out of the present crisis and grow to thrive in the future, at least in the medium and long term? In studying this plan, in studying the company and arriving to the proposals, have you considered and compared the company's performance and projections against the industry averages? You see, the industry is your benchmark. How is it doing? How will the industry react? If, for example, you think you can enter the market and undercut prices, how is that market going to react? If it is going to be a solid market, a solid competition, and they also decide to undercut you, they can probably sustain that war longer than you. So these are some of the things you have to take into consideration. What is your leadership team like? Is it in position to implement? They may be right for the organization, but wrong for the implementation. They may not be able to drive that implementation. Are they adequately motivated? Motivated for it? Are they ready for a fight? If someone is about to retire and you tell him that, I want you to hang around so that we can grow this thing, but he's thinking of retirement, his frame of mind is not there. He might be good, he wants to serve on a board elsewhere. Number 5, do you have the support of key creditors? The key ones, like the secured lender. The secured lender doesn't have to sign your deed. He need not sign your deed. I think that's section 164. He doesn't have to. So whatever you want to do, you run around, you posture, you're going to come to him. And if he doesn't sign his deed, that deed, what does he do? He walks away with security. So unless you can do without his security, you must in court the support of the secured lender. Do you have funders that are supportive? How are they going to be supportive? What's the nature of their support and how does it relate to the business? What sustainable plans do you have for creditors and key management staff that may not be supportive of your plan? If your secured lender says, I am not supporting this, or there's a certain staff who says, no, we've seen this before, I'm done, I'm not, what are you going to do? What's your contingent plan? Are you buying the lender out? Because you will welcome that. Is the plan the kind that any person intelligent and honest, a businessman, anyone can support, can approve? Is it that sort? You know, for some of these banks that we represent, you've had people that come who have borrowed and are required to pay, let's say, 10 million shillings a month. It runs into trouble, then he comes and says, no, I can only afford 500,000 a month. Is that even reasonable? So do you expect at a voters meeting, at a creditors meeting, to table such a plan and it is accepted? Is there something about this plan that is maybe somewhatly likely to be challenged legally? Is there potential of challenge for either its applicability or legality somewhere? Now, those are the ones that where you will need stakeholder support, creditor support most. Because they'll look and say, well, that's a tightrope you've taken over there. I will ignore it because you've talked to me, because I see what you're trying to achieve. Let us pray together that you'll achieve. So that sort of thing can happen. But if you don't engage that secured lender, he's going to be part of the group that will shoot you down at the creditors meeting. In that creditors meeting, you need people of say that can speak for you. And so that is why it is important to have secured lenders and key stakeholders on board. So it is important you have them. And that you, as the IP, as the insolvency practitioner, remember the law requires you to write a report to court, to confirm to court that you have reviewed this report and you can personally vouch for it. So in some sort of way, your own credibility and professionalism is at test. So that's why is your report. Can you vouch for this plan? Do you think it can work? So that's your personal stake at this point. So that's the plan viability test, the things to consider as you prepare this plan. Oh, sorry. Did I go forward? Oh, sorry. Sorry, I seem to be going backwards, so let's... Oh, okay. Sorry, I didn't handle this right. So, what are the key lessons we can take home today? I thought that these 6 lessons would be good for us. Number one, when you have instructions to get an interim protection order for your client, you must have a well-articulated plan or proposal before you do that. So take time to prepare one. That means that the company that is going to take benefit of the interim protection order is one that has got to be honest to itself early enough. This process involves introspection. If you avoid the introspection, you're likely to end up in a knee-jerk reaction like GLC ended, and then the whole process will fall flat on its feet. So, a plan, a proposal, prepared in good time. Preparation of an IPO, plans and proposals take time. The less time you take to prepare, the dimmer your chances of success. To succeed in your plans, the plan must have the support of the secured lender. Actively engage the secured lenders. Talk to them formally and informally. Identify creditors of influence and power, and also court their support. So in other words, please profile your creditors and know who to talk to and what to say. You don't have to talk to all of them. For the others, you can send the SMSs and what have you, but the important ones, the ones that are going to influence the people on the floor, you must talk to. Keep channels of communication open. Speaks to the formulation of a communication strategy that I made earlier. Important is that you must keep control of that narrative. Lastly, as professionals, let us cooperate, because that's the way to create value. I do not know what, I don't see why, for example, in the case of GLC, as professionals, we somehow fail to talk to each other. We probably could have done better. I do not know why the provisional administrators did not feel it right to go and meet the lenders personally, bank one. Don't get caught up in the emotions of the client. You are a professional. Go and have word with the banks and see what you can offer, both in office and outside office. That's the way it works. The whole idea of writing a letter that please come to me and meet me in my office. Yes, they will come. It happened in this particular case. The provisional administrators wrote to the bank MD and said, come to our office, we'll be here to meet you. The bank came. What do you think, kind of discussions do you think were had at that moment? So let's have let's talk more as professionals. Let's cooperate. We are, after all, avenues of communication anyway between our respective parties. So, Mr. Chairman, I think with those few words, I hope I have been useful to the subject.
Thank you so much, Mr. Kavito Karamagi. We've had a very enlightening discussion, and I am certain there are so many questions that we have at this moment. And of course, let's not lose sight of the key takeaways. Let's not lose sight of the fact that when it comes to interim protective orders, we must prepare our plans in time. Let's not lose sight of the key creditors that we need to engage as we're having these discussions. Let's not lose sight of developing a robust communication strategy in order to ensure that we are effectively communicating to all those that are likely to be affected by the plan and those who are going to benefit from it in the long run. Mr. Kavito Karamagi, we thank you so much for your time. And we see a series of questions in the chats. In the interest of time, I think we shall pick out 3 of them, of course with guidance, but we can pick out 3 of them, we address them, and then we promptly move to our next speaker, who I believe is already waiting on us. Okay, so the first question So the first question we have, well, a question from, you can read it.
Yes. I see a question from, or is it a comment from Bitature Vicent? Thank you for the presentation. What you're explaining has a semblance of what is happening to our local company. Okay. Whereas DLC went to banks, Rocco yelled out to the political scene. I hope I'm right in my observation. Well, I hope you're right too. I don't know. I don't know. Let's see. I see. Can you please? There's a creaking noise. I'm looking for a comment, really. Well, Vincent, you have done fairly well in you're very active. Thank you. Okay, no questions? Seem to be comments.
Okay, so please keep those questions coming in as and when you're able to, and we'll address them in the course of our discussion today. So we're moving on to our next very enlightening topic from a gentleman that is very well known to most of you. We will be hearing from Dr. Abdul Salam Waiswa, the head of Legal Affairs at the Uganda Communications Commission, and he is going to take us today through the impact of insolvency on employee rights, specifically balancing the protections and balance realities. As insolvency practitioners, we have certainly come across incidences where we have to deal with outstanding employee issues, and we have faced extreme challenge in how to resolve them. Luckily today, we have one of our very own to take us through how this can be handled. So, a really brief profile about Dr. Waiswa. As I've mentioned, he's the head of legal and compliance at the Uganda Communications Commission, the converged regulator of the communications sector in Uganda, with a mandate to license, supervise, and facilitate the development of a robust communications sector in Uganda. As the head of legal and compliance, Mr. Waiswa oversees the legal advisory, licensing, litigation, prosecution, as well as the compliance and enforcement functions at the Commission. He is an advocate of the High Court of Uganda with a doctorate in law from the University of South Africa, with a Master of Laws in Corporate and Insolvency Law from Nottingham Trent University in the UK, a bachelor's degree from the University of Dar es Salaam in Tanzania, and a postgraduate diploma legal practice from LBC. Interestingly, Dr. Waiswa's LLD thesis focused on the evaluation of the strengths and weaknesses of the South African corporate rescue framework as a potential benchmark for Uganda. He has participated in several local and international trainings in ICT and media policy formulation, and previously worked as the manager debt collection at URA. In 2014, Dr. Waiswa authored a book titled The Fundamentals of Law in Uganda, and has written a training book for the Institute of Banking and Financial Services on the principles of law, as well as the law related to banking and financial services in Uganda. It is indeed a privilege to have him here today to speak to us about a very pertinent topic. Dr. Waiswa, we welcome you, and I hand over to you. Thank you so much.
Thank you very, very much, my brother, for the warm introduction. Good morning, all our colleagues following online. I'm humbled to be joining you this morning to deliver this lecture and let me say discussion on the impact of insolvency on employee rights and how we can balance protection and business realities. Like Dav introduced me, indeed, I'm Dr. Abdul Salam Waiswa. I work with the UCC, but for purposes of this discussion, I wish to declare that I'm here in my capacity as an advocate, as Waiswa, Dr. Abdusalam Waiswa, who also happens to be a director in the company called Salam Associates, under which we provide a number of myself and a team. We provide advisory service to people on issues of insolvency, taxation, employee relations, and many others. So as I speak today, whatever mistakes I'll make during my presentation should be attributed to me as Abdusalam Waiswa and not my employer, the Uganda Communications Commission. And that's why I prefer to use the logo of my private company and not that of UCC to avoid mixing the official position of UCC with my submission before members of ULS. But I'm still happy to engage in this discussion. I'm very happy, and Mr. Kavito's discussion, I'm sure, has opened our eyes to a number of issues, and therefore I'm happy to be speaking after him. Basically, these presentations rotates around insolvency and employee rights. But certainly, before we can have a proper discussion, a balanced conversation, it's important for us to appreciate the fundamentals of the subject of law and practice that we are dealing with. You know, insolvency is one of those very critical terms for the understanding of law, insolvency, bankruptcy, and reorganization. But unfortunately, in many countries, the laws do not define what insolvency means. Therefore, in this discussion, I will try to throw some insights on what actual insolvency means, what its impacts are on the rights of employees in Uganda, and also how, as practitioners, we can balance the need to protect employees' rights vis-a-vis dealing with the business realities. If you speak to any business rescue practitioner, they will tell you that many times what is written in the law is different from what we find in the field when you are told to advise on an issue of insolvency or bankruptcy of a business. Because most times when trouble sets in, things is being normal. And therefore, a lot of things are done informally. A lot of things do not follow the written down rules and regulations. And therefore, as an insolvency practitioner, it's important to always prepare your mind for anything. It's not good for you to just read books, to read the law, and expect everything to unfold the way it is written in a book or in the statute. So in this discussion, I'll try to mix what the law says together with the reality on the ground. I'll also try to look at some of the obvious rights of employees and how these are affected when a company or an individual becomes insolvent. We'll also talk about how practitioners can protect employees better, but also around the same point, we'll try to discuss about the roles of employees in supporting their businesses or their employers' companies to survive. Because at the end of the day, when a business begins to crumble, employees are the first victims. So, and yet they play a very critical role in the continuous operation of the business. And therefore, as a practitioner, it's important to always regard employees as a key stakeholder, without whom you may not be able to progress much. Even when the law is on your side, an employee can frustrate your plan, an employee can frustrate whatever ideas you could have. So we shall also come up with some possible recommendations, especially picking on from what the laws in other countries, and I picked out South Africa as one of those model countries that I think we can copy a lot from if we are to improve our legal framework in Uganda on insolvency and corporate rescue. So coming back to the presentation, what is insolvency? I've already noted the law does not directly define it, because as you see in Section 2 of the Insolvency Act, there is only a definition that insolvency includes bankruptcy. That is not actually a definition. But the good thing that this is a word that is used widely. It's an English word, so it has acquired a lot of meaning in many people's mind. But for certainty, we try to refer to law dictionaries, English law dictionaries, to tell us what does it mean. The Black Law Dictionary defines insolvency as a condition of being unable to pay one's debts as they fall due and in the course of doing business. You realize that in determining whether or not a business, and that includes a company or an individual, is insolvent, the number of tests that globally are acceptable in determining whether indeed somebody is insolvent. Most times, insolvency is triggered by inability to pay debts. So most of the laws in our countries usually tag insolvency vis-a-vis inability to pay debts. And so whenever somebody is unable to pay their debts, as and when they fall due, under the law, such a person, be it individual or a company, will be deemed or presumed to be insolvent. But in doing so, there is emphasis that insolvency looks at mainly two tests. You can become insolvent on a cash flow basis, but also be insolvent on a balance sheet test. Sometimes the cash flow test looks mainly at your capacity to pay debts as and when they fall due, depending on the money, the funds that you have at your disposal at a time. Many times, businesses become unable to pay debts because of different reasons, even when those companies or individuals are rich. And in Uganda, the law is bent on the cash flow test, that it does not matter how wealthy you are in terms of property. What matters, are you able to pay your debts whenever they are demanded? So the balance sheet test primarily looks at your asset base and liabilities. So in accounting, and we have all done balance sheet formulation, to know somebody's financial health, you look at how many assets they have, the value of the assets vis-a-vis the liabilities. If your assets are more than the liabilities, then the assumption is that you are still solid, you are solvent. But also, if your debts are more than your assets, then naturally you are deemed to be financially distressed and you are insolvent. However, in trading environment, there are so many individuals and companies that have a lot of property, but when they don't have cash flow. And under the Insolvency Act of Uganda, Section 3, which defines what insolvency, what inability to pay debts means, focuses largely on discontinuous ability to pay one's debts when and as they fall due. It does not look so much at the balance sheet model. So those of you who are listening and your clients are there, they are wealthy, they have a lot of assets, they have property, they have land, you need to advise them that even with their land, with their hotels, with their businesses, with their bank balances, if they don't have discipline to pay debts, they can easily be subject to the insolvency machinery just because of not paying their debts whenever they are demanded. In fact, under Section 3 of the Insolvency Act, the debtor is presumed to be unable to pay debts if he does not settle a statutory demand. A statutory demand is defined under Section 4 of the Insolvency Act to mean a demand or a notice that somebody receives from a creditor informing them that a particular amount of money that is owed to them is outstanding. And the expectation is that you must settle that statutory demand. And if you don't settle it within 21 days, then that person can presume that you are unable to pay your debts. And every time you are unable to pay your debts, somebody can commence insolvency proceedings against you. And when they do, it's not enough for you to go to court with your balance sheet, with your list of assets, and show that you actually have many properties that are worth a lot of money more than what is being demanded. What is important is for this person to prove to court that the debt they are demanding from you is not challenged, it's not disputed, it is clear, it is due, and you've not paid it after they demanded for it. So that needs to come out clear. Then, of course, when execution proceedings are issued against you as a debtor and the same are returned unsettled, this could be after somebody has filed a suit against you, and in accordance with the law and the civil procedure rules, they apply you for execution under Order 22, and they may be try to attach your property or maybe recover money from your creditor through garnishee proceedings. If that execution process is returned to court and is satisfied, that can also be one of the grounds upon which a creditor can presume that you are indeed unable to pay debts, and they become justified in petition to either liquidate you or subject you to receiver to bankruptcy proceedings if you are an individual. And then also where the debtor's assets are substantially under control of a receiver, that can also be another indicator that you are indeed unable to pay debts. As we shall see later on, receivership is a known historical debt collection procedure that is also tied to insolvency. Most times, by the time a creditor appoints a receiver, you will have defaulted on your obligation to pay debt, either arising from a contract through security instrument or a debt, and somebody chooses to apply for appointment of a receiver under the civil procedure rules. So once your property or a substantial part of your asset is under control of a receiver, that can also be an indicator that you are indeed unable to pay your debts. But in addition to that, Section 3, Subsection 3 of the Insolvency Act goes on further and open the gates by saying that actually you can prove inability to pay debts through any other means, which means that even where they have not issued a statutory demand, execution proceedings have not been filed, there is no receiver appointed, if somebody can demonstrate through other means that indeed you are in a financial distress position and you are unable to pay your debts, they can actually sustain an application or a petition to declare you insolvent or bankrupt or subject to any of those other insolvency proceedings. And remember, in Uganda, it is also not even for a company, the amount of money that somebody needs you need to owe somebody before they can deem you to be unable to pay your debts. For a company is only 2 million, and then for an individual it is just 1 million. So imagine how many of your clients have unpaid debts of more than 2 million or 1 million. If they have many people that they owe money beyond that limit, that means that already under the law they can be deemed to be unable to pay their debts, and they can be subjected to the machinery of insolvency. Now, insolvency is caused by so many factors, and because of our topic today, I will not so much delve into the causes, but the causes are many. Could be because the business environment has changed, because the environmental system has changed, it has become onerous for you to run your business. It could be changes in technology, where, for example, some of your business operations are rendered redundant by advancements in technology. In some of my writings, I've given examples of companies that were, for example, dealing in typewriters. I mean, with the coming to play of computers and laptops, you no longer need a typewriter. So people who are in the business of manufacturing typewriters, naturally, technology caused them misery. People are dealing with, for example, half petties for ladies. They're no longer, most of our ladies these days don't put on half petties. If you ask some of these young girls if they even know a half petty, they may tell you we don't know it, because to them it's not important. They prefer putting on these light, small, sometimes even transparent attires. So people were dealing in such items naturally. The times have overtaken their business, and therefore they should be struggling unless they were innovative enough to change the line of business. But for purpose of this discussion, employees also sometimes cause their employers to run into insolvency, because employees control the business. So if employees are doing well, they are able to implement the ideas, the vision of the investor. But where employees are not being professional, they are not productive, they are inefficient, the business, however good it is, however capital solid it is, it can end up struggling to sustain its operation. So employees, whereas we are talking about how we protect their rights, it's also important for us to be very clear that sometimes bad workers can actually harm business and end up exposing it to more trouble. We also see companies that have a lot of staff, Some people think that it is trend for you to say that I hire 500 people in my company. That can be a business mistake. It's important for investors to know how many employees they need, such that they can avoid overemployment of people. When you do that, employment expenses are a constant expense. You pay somebody's salary, you get office space for them, you pay for them NSSF, you pay for them payee. All those are expenses that you incur as a business. So if you hire many people, you could easily struggle just because you were trying to support people and give them jobs. So it is important, even as business rescue experts, when you are approached by a company to advise them on how they can improve their operations, it's important for you to look at their staff wage bill and also list of employees and ask, what do these people do? Sometimes you might find that the company is struggling because it has so many laborers than it actually needs. And if that is identified early enough, most times the company can be guided back on the right track. And then also, it's important for people to know that business is business. It's not a charity. So this tendency for people saying, I'm proud to say that I'm employing 1,000 people in my business is not really helpful. You might be clapped for saying that I hire 500 people, but the question is, what value are all those employees adding to your business? If they are not adding value, then it might be necessary for you to employ what we call austerity measures and downsize, hive off some of the unproductive units, maybe restructure the business, restructure the operations, hire employees with multiple skills. I mean, there are people in some industries where you find a person can be a salesperson, can be an accountant, can be a receptionist, can do so many things. So try as much as possible to look for people with multiple skills, because those become helpful to the company and they can help you to save on the extra expenses you might incur on those employees. So that aside, if indeed you've tried to use all those measures to avoid being insolvent, you are disciplined, but circumstances force you to become actually unable to pay your debts, the law provides a mechanism through which you can actually enter into formal insolvency procedure. And these procedures can be commenced by so many people. It can be the debtor, it can be a creditor, it can be a director, it can be a shareholder, it can be a contributor. Sometimes even regulator can actually commence insolvency proceedings against an operator in the industry that is not operating well. So when this machinery is started, a lot becomes controlled and defined by the law, not business interests, not individual business discretion. Most times you lose control over the business, and control will fall in the hands of another person who may not necessarily have the same vision as you, and also who may not have the same interest as you, the person who started the company. And in Uganda specifically, and the larger part of the Commonwealth countries, we do not have what we call debtor in possession proceedings as it is in the US, where even when insolvency proceedings are started, the debtor remains in possession of the company and the business. They continue running it, especially where they have taken on the route of Chapter 11 proceedings on reorganization. But of course, even in the US, they also have Chapter 7 proceedings on liquidation, which sometimes can also remove the directors from the company. But largely in the US, their model is that even when a company struggles, the directors, the managers should be left in possession of their company, because of the assumption that maybe they have a better vision, they know how to run the business, and they only need support on how they can better manage their affairs and regain solvency and continue operating. But in Uganda, the general principle is that whenever a company enters insolvency proceedings, the managers, the directors, the owners of the company are divested from the company, and control and management is handed over to an independent person who takes charge of the company and begins running it for the benefit of mostly the creditors, but also sometimes, as we shall see, for the benefit of the individual that appointed them, like in case of receiverships. What is the objective of insolvency procedure? The objectives are many, but in this case of Dioxti Bengana versus VJ Reddy, Justice Musa Sekana tried to summarize what I would call the general objective of the bankruptcy and insolvency machinery. And this was again picked up from the earlier case by Justice Madrama, where they both indicated that indeed proceedings in bankruptcy, and this can include, you can substitute that with insolvency, are meant to compulsorily administer a person's estate for the benefit of his or her creditors. The primary objective of bankruptcy law is to administer the estate of an insolvent person so as to enable him or her to pay the debts. This is partly because most of these proceedings are focused on supporting creditors, supporting the creditors to recover their money. So most of the rules are targeted towards that objective. We can have secondary objectives, but primarily insolvency law and its procedures are intended to facilitate creditors to improve their collection of whatever is owed to them by the debtor. And this is derived from what we sometimes call the creditor wealth maximization policy or objective, which says that in insolvency proceedings, the primary objective is to help creditors to recover whatever money is owed to them by the debtor. And the insolvency practitioner is primarily supposed to focus on that objective, and in doing so, we find many other stakeholders suffering or sometimes losing. And this is why even employees sometimes suffer, because when an administrator is appointed, as we shall see, the primary objective is on how do I save money for my creditors. If a liquidator is appointed, he will not so much bother about your children that are depending on your salary to survive. The liquidator's objective will be, how do I make my creditors happy? And this, but also the insolvency machinery tries to facilitate equal distribution, equal and fair distribution of the available property of the debtor to the petitioners and the creditors generally. This principle tries to ride on the principle on the history that individual debt collection processes sometimes can be unfair to some people. You might find that if a bank appoints a debt collector, the debt collector can sell the property even if that property is all that the company had, and it is that property that had the potential to generate more money than even what was being demanded by that person who was appointed the debt collector. And in doing so, sometimes the general board of creditors is affected and everybody ends up losing. So insolvency tries to level all parties and ensure that we have some bit of collectivism to bring all people on the table. Let them lay their claims together and let the insolvency practitioner look at each one of them and apportion the benefit in accordance with the rules provided for under the law. This is the principle of fairness. Is it fair? Sometimes it is not very fair, especially when it comes to secured creditors, but that can be a debate, a discussion for another day. And then also, for individual insolvency, sometimes the insolvency machinery seeks to help the debtor to be relieved of the pain that they go through because of an inability to pay their debt. So sometimes when a debtor is unable to pay their debts, they get stress from so many people, all of them calling them, all of them attaching their property, arresting them and putting them in civil prison from time to time. So what the insolvency law machinery tries to do is to help this person hand over their affairs to another person. And that person manages all the creditors. And once all the creditors' issues have been resolved, either they have been paid, or if they have not been paid, all assets have been recovered, the debtor can be given a chance to be born again, to relive their lives without having to be heckled, to be arrested, to be harassed by all the many creditors that could be surrounding them because of the historical debt. So insolvency law also facilitates a debtor to get discharged and be born again without being haunted by the historical mistakes. Again, this arises from the historical perspective that sometimes not being able to pay debts is not the worst crime. Sometimes people become unable to pay their debts not because they are deliberate, not because they are fraudulent, but because of circumstances beyond their control. So this principle is what, in a way, ushered in the new philosophy of business rescue, what we sometimes call the fresh start approach to businesses, that if somebody fails in business, you have to try to give them a chance to start afresh, because merely because you've made a mistake 10 years ago, it doesn't mean that you cannot run a business today. So the insolvency law mechanisms allow somebody to be reborn, to be discharged, and be allowed to regain their normal operation. What are the effects of insolvency on employees? The effects are many. There are many, and indeed, most times, employees are the first people to lose when a company closes. Because most of these employees, you find this job, this company, in addition to being a job, it is that source of livelihood. And in Uganda, you know, with our dependence levels, you have one job, you are earning a salary, but that salary is not just for you, it is for the entire clan. You get money, you pay school fees for many people, you are paying tithe in your church, in your mosque, you are paying zakah, you are helping many people off that job. So most times, when a company that was employing you closes, there are so many dependencies that are affected by that closure. And that's why it is always important for us to think about models through which we can, as much as possible, minimize the impact of insolvency on employees. But is that possible? Most times it's not possible. And for most legal regimes in the world, unfortunately, employees are seen as the lost soul. They are seen as the lost souls because most times the law, the proceedings, the approaches taken by courts are not to support employees, but rather to facilitate either recovery of money by creditors collectively, or to help the company to regain its stability and be able to trade again. Now, in achieving one of those objectives, most times employees are not left untouched. They will be sacked, they will be terminated, their contracts will be renegotiated, they will be demoted, and this becomes a natural consequence of insolvency. It's just like we say, you cannot have an omelette without breaking an egg. If you must have that omelette, lazima, some eggs will be broken before you can have an omelette. So even when you're dealing with insolvency proceeding, most times, naturally, employees will lose jobs. Not everybody will remain there, except the very critical ones. And in doing so, the impact becomes big to those individuals. Are employees completely exposed to risk? I would say in Uganda, under our Insolvency Act, unfortunately, the law exposes employees to a lot of risk. They are not adequately protected, and many times by the time a company shows signs and symptoms of inability to pay debts to the external people, it will have taken months without paying its employees. Colleagues who have handled insolvencies in this country will tell you that sometimes by the time they are appointed, employees have not been paid for a year, for 6 months, for 2 years, others for a longer time. And this is a reality. This is a reality because usually in Uganda, most companies pretend. Companies limp for many years, and they take too long to realize that they need support. And in business rescue and insolvency law, we say that just like humans, when we fall sick, we need to go to the doctors. And the doctors tell us that it is better when you go to a doctor early than later. Because when you go early, you are able to be diagnosed before the disease has moved from stage 1 to maybe stage 4. But for most companies, by the time they call upon an insolvency practitioner, they are almost in stage 4. They are terminal. They are actually beyond rescue. And this is unfortunately a very big problem, because the longer you take before you engage an insolvency practitioner to help you, most times you worsen the situation, and usually at that time employees will have suffered a lot. Now, the Insolvency Act, like I've already noted, is largely silent on the rights of employees, but in some provisions there is recognition that employees will have some protection, and I'll be going to that specifically. And also, when you look at section 12.5a of the Insolvency Act, it also recognizes that whenever a company undergoes insolvency proceedings, then unpaid salaries and wages for a period of 4 months before entry into insolvency, those wages and salaries will be deemed to be preferential payments, which can be paid. But unfortunately, when you look at that section again, you discover that even with that protection, the protection is so weak, because you find that by the time you reach to 5, there are so many other preferential payments which take priority ahead of wages and salaries. Yes, in 2020, Parliament amended and removed payment of taxes, but even with that amendment, still by the time you get to employee wages, you'll have already paid, for example, the cost of insolvency proceedings, you'll have paid the receiver administrator, you'll have incurred all those other expenses, which most times will eat up whatever money that is left in the estate. And so by the time you get to employees, practically you don't even have any money to pay them. So that protection, I can state, is also weak. But yes, there is that recognition. And then also, when you look at Section 30 of the Employment Act, it covers, it provides something about employees by indicating that whenever an employer enters bankruptcy or winding up, and that person's business closes, the assumption, the law presumes that in a month from that time, all the employees' contracts will be terminated by operation of law. That's the position under the Employment Act. It talks about 30 days from the time when, 1 month from the time when the company enters into bankruptcy, winding up. For this case, these provisions are anomalous to many other provisions, so they are deemed to apply to all other processes. But as we shall see later on, for even other insolvency proceedings like receivership, the law is even stricter. It says immediately. But I'll go through the specifics of how the Insolvency Act treats each one of them. But also, the same act goes on to say that where, as a result of insolvency, the business survives and it is transferred to another person, then employees their contracts will be protected. But we shall discuss later and see that even with that, the Insolvency Act, which came into force much later than this Act of 2006, made a number of changes, and going by the principle of a later law taking precedence over an older law, and also a subject matter law being superior to a general law, then the positions under the Insolvency Act in a way overrun and override the provisions under the Employment Act in terms of the periods, in terms of the treatment of employees, but also in terms of Section 48, which talks about the 6 months. Because when you look at Section 48 of the Employment Act, it provides that whenever an employer terminates an employee's contract because of insolvency or bankruptcy, then the employee's wages and salaries for 26 weeks, which is about 6 months, are supposed to be treated as preferential payments ahead of all other claims. But that now is contradicted by Section 12.5a of the Insolvency Act, which limits this period to 4 months, not 6 months. That is one contradiction. And also, as we shall see, the other insolvency proceedings under the law provide other restrictions beyond what is provided for under the Employment Act. And like I've already noted, in my view, though some of these provisions have not been adequately tested in our courts, but in my view, if there is a dispute over what periods and what procedure takes precedence over the other, courts are likely to hold that the provisions in the Insolvency Act take precedence over the provisions in the Employment Act, because of, one, the Insolvency Act is a newer law, and therefore there's something that by the time Parliament was making that law in 2011, it knew about this Employment Act and therefore chose to go with a shorter period. And then also the fact that Insolvency Act is the primary law on regulation of insolvency matters in the country. So what is the impact of specific insolvency proceedings on employees? Here I've tried to highlight some of the common insolvency procedures in Uganda and how they directly affect or impact on employees. I begin with liquidation and bankruptcy. As we know, liquidation is for companies and bankruptcy is for individuals. Sometimes these two words are used interchangeably, but technically speaking, liquidation applies to companies and bankruptcy applies to individuals. And the Insolvency Act provides different procedures for declaration of individuals bankrupt and also liquidation of companies. There are different modes of commencement of liquidation. There is also a procedure on how an individual can either commence their own bankruptcy processes or a creditor can cause a company to, a distressed debtor to be declared bankrupt. So all those processes are provided for under the Insolvency Act. So the objective of both of these processes or proceedings are almost the same. In both liquidation and bankruptcy, the objective of the procedure is, one, to allow for collective recovery of debts from the insolvent. So these proceedings occur when indeed a debtor is insolvent. There is evidence that one, they are unable to pay their debts, they have not paid their debts, and all these are known. And once court grants the order, or voluntarily the creditors or the company chooses to go through a creditors or members voluntary liquidation, and that liquidation is deemed to start depending on the mode through which it was started, the primary objective, once a liquidator is appointed, is for that liquidator to ensure that they collect all the assets of the company and distribute the proceeds to all the creditors in accordance with their ranking as stipulated in the Insolvency Act. Same with bankruptcy. When a debtor is declared bankrupt, the trustee in bankruptcy that is appointed, his or her primary objective is to ensure that all creditors are invited, their claims are vetted, and those that are proved and found to be due, they are settled out of the proceeds of sale of the assets that the debtor could have had before the event occurred. What is the impact of all those processes? Primarily because these proceedings are aimed at ending the business. Most times the liquidator or the trustee in bankruptcy, they will be focusing on closing the business. And therefore, because of this, most times they will close the business immediately and begin looking for assets. And because the employees primarily facilitate normal operations, when a liquidator closes the business or the trustee in bankruptcy, the employees will be sacked immediately. They will be sacked immediately, and that becomes a reality. And then if they have any unpaid debts, they will be expected to claim like all other creditors. And of course, once money is collected, they will be paid whatever is due to them in accordance with Section 12 of the Insolvency Act. But this is largely dependent on whether indeed there are any assets from which money can be recovered. And then now this is where sometimes there is a contradiction, because when you look at Section 61 of the Insolvency, it generally says that this liquidator ordinarily should close business and only keep it running for as long as it is deemed necessary for purposes of facilitating effective liquidation of business. Now, sometimes the liquidator might go to the business and discover that if I shut it down once, I will lose value. Because indeed, when you close a business, most times it loses value. People are attracted to operational businesses. So even liquidators, most times they make a judgment call and say, yes, whereas my primary role is to close the business and sell its assets, sometimes you have to evaluate and say, how much will I get from this business if I sell it closed, or if I kept it running for another 2-3 months until I'm able to get a buyer. So many times the liquidators make that decision and keep the business running for a few months. Now, why a liquidator makes that decision, the assumption is that he will look at the employment contracts and adopt a few of them, adopt those employees that he considers necessary for him to continue running the business. If that happens, then those employees will become employees supposed to be paid by the liquidator. And the liquidator in doing so can even negotiate terms and say, you were being paid what, 10 million? I'll pay you 5 million. I'll pay you 2 million. You are a manager now, I'll make you an officer. And maybe out of 100 people who are working for the company before this event, the liquidator might only retain 10 or 20, the critical staff, and those will be paid. But for the others that are terminated, the assumption is they will go back and wait. Once the liquidator has completed the processes, they will be paid in accordance with the rules on distribution of assets. That most times will be the first impact, because of course when you lose a job, you realize that you've almost lost everything that you thought you had in the business. Now, for rescue proceedings, like we said, there are many insolvency proceedings: provisional administration, individual arrangement. All these are provided for under the Insolvency Act. Provisional administration is the entry procedure through which a company goes where it chooses to say, okay, I have many creditors demanding money from me, but I think this business has potential. Rather than liquidate it and sell it in piecemeal, let's take it under administration to allow renegotiation with the creditors, look for capital injection, look for maybe any possible option through which we can keep this business running beyond this event. So once the company directors choose to make that decision, they will of course go through a process. And now recently, under the 2022 amendment, provisional administration can even be started by a creditor. Previously, this could only be started by the company itself, and there had to be special resolutions, but now even a creditor can petition court to place a company in provisional administration. And that was after the 2022 amendment to the Insolvency Act. Similarly, administration is after you began with provisional administration. If the administrator conducts what is called a diagnostic review of the business and confirm that one, the business has potential to be saved, and also two, that maybe even if the business cannot be saved, we can generate more money for the creditors if it is kept running for a longer time than if it is closed immediately. Then the business rescue expert that has been appointed will have to convince the creditors. And once the creditors are convinced about the potential of this company, they will sign an administration deed. Once they execute an administration deed, that is when the company now will move from provisional administration to administration. And provisional administration is supposed to be for a very short time. To allow entry into administration. I will not so much go into the other details that happen when these processes are happening, but yes, there must be a negotiation and the creditors must be convinced about the potential of this company before they can agree to sign an administration deed and keep it operational. Now, once that happens, and maybe also I can also talk about individual arrangement. This is for individuals. Even an individual, when they feel that actually they are stretched by the debts, they can choose to go through individual arrangement, which is more or less like the same procedure as administration for companies. But again, this involves the data, the individual data, approaching the creditors and choosing to appoint a supervisor who will engage all creditors, show them how this person's business affairs can be rearranged, reorganized, restructured, and might be helped to survive, When that happens, again, the company will execute an arrangement, the individual and the creditors will sign an arrangement which will now be overseen by the supervisor, and objectives for the business to be allowed to continue operating. Now, once that happens in any of those proceedings, Section 158 of the Insolvency Act again presumes that the administrator will have to engage some of the employees of the company to assess their contribution to the company. And the law gives the administrator 10 days within which to look at all these contracts. And within that time, the law mandates the administrator to adopt contracts that they consider necessary and also to terminate others that they don't consider necessary. And this is a critical time for you as an insolvency practitioner. You must be able to look at the payroll of the company and confirm whether all the employees that were being employed by this company before its entry into administration, into provisional administration, are necessary. If you find some of them unnecessary, regard them redundant and terminate them immediately within 10 days. Because if you don't do that within 10 days, then Section 158(2) of the Insolvency Act could hold you back and you might be deemed to have adopted all those contracts. Now, what happens during that time, the 10 days period? Employees at that time are expected to work with the administrator and look at their contracts, look at their job roles, look at their job description, and agree on the new terms and the condition of service during administration. At that time, the administrator will be at liberty to renegotiate terms and conditions. Can say, I'll give you you are the managing director, you were earning 20 million. I don't think the company can pay you 20 million, or we can only pay you 5 million. And maybe you had a contract of 5 years. We are not sure how long this process will go on. We will not give you a 5-year contract, but shall give you a monthly contract that will be renewed every month depending on your performance. This is where the delicate balance has to be done by the practitioner, because if you try to seem fair to the employees, chances are high that you lose your core objective, because sometimes these employees could be the same people that caused the company to struggle. They could be the people that were underperforming. They could be the people that were actually fraudulent. They could be the people that you actually are going to investigate and even refer to the office of the official receiver for investigation and maybe prosecution, because the law allows you to report an individual that you consider to have actually committed any crimes before the company went into insolvency proceedings. So, as an insolvency practitioner, you must play a critical role here and use your instincts. Look at the management reports if at all they are there, and speak to the critical staff of this company and know which staff are important and those that are not important. For the less important one, don't be shy to terminate them, because if you don't terminate them, they will hold you by the old contract. There will be an assumption that you adopted their contracts and they might demand money from you. There is a case I've taken note of this morning, but I don't have the full facts of the case and also the decision, but maybe our colleagues can research more about it. I was trying to look for it to properly internalize it on this matter, where somebody during the administration of UTL, their contract was not adopted during the 10 days, and the administrator kept them working. And then afterwards, the administrator wanted to terminate them without giving them, I think, some terminal benefits and all that. And the employee challenged the termination, arguing that from the time the 10 days ended, his old contract was deemed to have been adopted by the administrator, and the administrator was bound to the contractual terms under which this person had been hired before administration. This case is called Hamdin Al Salim Abubekar versus UTL. It's Labor Dispute Appeal number 36 of 2019. I've tried to look for the decision of the industrial court, but somehow I hadn't gotten it, but those were the facts. But what I foresee, the court ruling on that point, I imagine, was that by the administrator not adopting, by the administrator not terminating this person in 10 days and keeping this employee working after that time, the assumption that you've adopted them. And if you adopt them by the command of the law, at that point, if you want to terminate them afterwards, you must follow the processes detailed under the Employment Act, including giving them notice, giving them a hearing, and then giving them whatever benefits they could be entitled to under that old contract. So as administrators, practitioners, these 10 days are very critical. We can have a debate whether 10 days are sufficient, but again, the objective of Parliament was that you should be very fast in diagnosing the company and come up with strategies on how you can revive it rather than being in that period for so long. But also the law allows you to apply for extension of time for all these timelines that are embedded in the Insolvency Act. So if you think 10 days are not enough, again, as an administrator, you have the mandate to apply to court and extend the timeline within which you were supposed to do that. Once you get that court order, and on good reasons, court can give you the time within which you can evaluate all these contracts. This could, for example, become necessary where you prove that, one, this company has so many employees across the country. You don't have all their contracts. You can't get the files. So you are unable to evaluate all of them within the 10 days. If you have all those reasons, I imagine court can be persuaded to give you more time. So during this time, as an administrator, you need to be very hard and balance the business need and the objective of reviving, resuscitating, and helping this company to survive its problems. So you must be hard and firm on these employees and not so much become emotional. Because if you become emotional, you may never make the hard decision to tell somebody who was earning 20 million that I'm going to give you 5 million. If you can't take 5 million, then go home. If you don't have that hard heart, you may not make that decision and it might affect you. Then what happens if you go through the same process I've explained for administration applies to individual arrangement. The process is more or less the same, even for individual arrangement. So I don't have to go through it in the interest of time. Now for receivership, which is another procedure that is used, as many people could be aware, receivership is an individual debt collection procedure. Sometimes there is misconception about receivership. People think receiverships are a collective insolvency procedure. But under the law and historically, receiverships are a debt collection procedure that are employed by an individual creditor to recover money from a debtor. So when a company appoints Abdul Salam as a receiver, and you are not that company, ordinarily under the law, I don't owe you a direct duty to give you what you demand from this company. My role is to, one, get into the company, get its assets, try as much as possible to recover from my client, and then hand back the company to the company, the directors. And if you also have your claims, you can either start another process or also start another enforcement procedure against the company. So I've seen many people saying this receiver has not given me my money. No, a receiver is primarily answerable to the grantor, to the person who appointed him or her as a receiver in that capacity. And indeed, under the Insolvency Act, because of that recognition, where a company is under receivership, it can also be taken under administration. And when a company is put under administration, at a time when there is a receiver, administration suspends the receivership. And the administrator is supposed to work with the receiver to ensure that there is collective recovery or management of the company. But that has to be started separately. But until that process is done and there is a court order granted by court, the receiver remains primarily responsible and answerable to the person who appointed him. And yet also remember, a receiver is deemed to be an agent, not of the appointer, but of the defaulter. So even mistakes committed by the receiver ordinarily are not mistakes of the creditor who appointed him. But of course, there is a lot of case law on when, in some cases, the appointer can also be held responsible for maybe the excesses of the receiver, but primarily, the receiver is an agent of the creditor, of sort of the debtor in whose business the receiver has been managing. And also, receivership could be both the ordinary receivership or administrative receivership. The difference is that administrative receivership involves continuation of business. Usually for administrative receivership, the receiver will move in and take charge of the company assets and continue running it for the benefit of the grantor or the appointing person. So if it's, for example, a petrol station, or let me say a flourishing maybe chain of business, as a receiver, sometimes when you move in, you might consider it necessary for you to keep the business running instead of closing it and selling it in piecemeal. Sometimes you may need to become an administrative receiver for purposes of running the business. And indeed, experience shows that when you operate it as an administrative receiver, you are likely to recover more money for your creditor, but also leave the business better for the person you're going to hand it over to, but rather than just closing the doors and selling it all like a dead animal. So though I just thought I could talk about now, for receivership, the law is even more explicit. Section 186(2) expressly provides that all contracts of employment shall automatically lapse on the date of commencement of receivership, which means this section overrides Section 30 of the Employment Act, because Section 30 is talking about a whole month, that the contract will be terminated after 1 month. But this one, the command of the law is clear that from the date receivership commences, automatically all contracts shall be deemed to be what? To have lapsed. And therefore my view is that for a receiver, the 10 days of adoption or not adoption do not even apply. The contracts will lapse, and then the receiver will have the latitude to pick out whatever contracts they consider important for them to continue using or relying on during the receivership. And then once the receiver adopts these contracts, the few that they pick on, they'll become liable and responsible for payment of any dues to the employees, including the statutory obligations like paying payee, paying NSSF, and other statutory obligations. What should insolvency practitioners do? I know we are about to close. As insolvency practitioners, it's important for us to encourage companies and individuals to always first consider business rescue before resorting to liquidation and bankruptcy. Because as you've seen, liquidation, receivership, and bankruptcy automatically affect the rights of employees. But business rescue, in addition to saving the business, it also allows the administrator to negotiate with employees and keep them running the business. Could be even on the same terms. So it is in the interest of everybody to keep the business running under business rescue procedure, except where you consider the company or the business completely irredeemable. But if it has a chance of recovery, please keep it running and try business rescue before you resort to the other harder insolvency processes. Then employees, it is important for us to advise employees wherever they are to always support the business that they are working for. Because when the business collapses, employees will suffer in equal measure, sometimes even more than the investors. Because sometimes the investors could have put in money, could have had ideas. If the business closes, they move on, and then they start another business. But you will have lost a job, you will have lost maybe your hard work for that company. So it's important for employees to support survival of businesses because they're not immune to the effects of what can we do maybe to improve the situation of employees in Uganda? My view is that we need to have a conversation on how we can improve the law to better protect employees. I know I've already told you the provisions of our current laws, but during my thesis, I looked at the law in South Africa and also a number of cases in South Africa. Their law is slightly better than ours in many ways, especially with respect to employees. In the Companies Act of 2008 in South Africa, it is very clear that when a company enters business rescue, employees are supposed to be maintained, and they can only be terminated to the extent that their termination is part of natural, ordinary attrition in the business. We know that normally business can terminate people, can restructure, that is okay. If you're terminating them after restructuring, that is permissible, but not this blanket and automatic lapse or termination of employees' contracts just because it has entered into business rescue. And even then, the law says that the employees must agree to the different terms and conditions that the business rescue expert might require them to comply with. Now, in Uganda at the moment, the administrator can give you the contract. If you take it, take it. If you don't want to take it, they will terminate you. But here, the law is saying they must agree, which in my view can try to help the employees. But also in addition to that, in South Africa, employees are defined as part of the affected persons with a lot of rights under the law, including the rights to petition court to place the employee in business rescue. So where, for example, an employee sees his bosses, the directors, mismanaging the company and seeing it going down the drain, when actually they know the potential of this company. In South Africa, the law allows such employees to petition court and seek for an order to place this company under business rescue. And this is very critical because sometimes employees will see the company going down because of administrative mistakes, lack of corporate governance structures, and therefore this measure helps employees to maybe help themselves to protect the company and also preserve their jobs. But also, when you look at the South African law, section 144, it says that in the preparation of a business rescue plan, employees must be consulted. Employees have to be consulted as a critical stakeholder because the assumption is that these people know the business better than you, the practitioner. They have been running the show, so they know where the loopholes are and where and how they can fix them to keep this company running. So in South Africa, you must consult them. In fact, there are cases where employees have challenged a business rescue plan on the basis that one, they were not consulted, or it does not reflect the realities on the ground. There are some cases from South Africa. So if we had this maybe in our act, we could also have some maybe better way of improving the welfare of employees, but also their role in the protection of businesses. But also too, employees are entitled to notice. When all these processes are happening in South Africa, the employees must be given notice before the appointment of a practitioner, before the placement of the company into business rescue, they must be given notice. Now in Uganda, the difference is so big. Employees sometimes don't know anything until a notice appears in the newspaper or until a liquidator comes in to close the offices. And that can be very, very gruesome and sometimes harassing to the employees. So I believe we can try to improve them. Then also the issue of employees' claims being regarded as super priority claimants. When employees are rehired or they are kept by the business rescue expert, Section 135 of the Companies Act of South Africa says any payment to employees, there is no time, no 4 months, no 6 months. Their payments are deemed to be part of what is called post-commencement finance. So just like money from banks that fund the revival, resuscitation of a company is given super priority under the South African law, even the money payable to employees who have worked for the company during business rescue must also be given priority. And for them, before you pay all other people, including the other post-commencement funders, the law says you must pay the employees their benefits. And in my view, that is a fairly moderate way of dealing with this situation. Of course, somebody can argue that South Africa's economy is bigger than us. When you put these clauses, we might burden people, we might frustrate rescue, but I believe we can have a conversation and see how we can marry the two models, the South African one, the one we have in Uganda, and come up with a hybrid that suits our circumstances. Of course, in Europe, the situation is even better because for them, employees are even entitled to redundance payment. They're entitled to payment in case the employers enter into liquidation and other insolvency proceedings. So if, of course, Uganda being a country at a level of economic development it is, we may not be able to ask for so much like redundance pay. I mean, it might be difficult for our economy, but of course that would be ideal, and I believe it would really help employees improve their welfare. So like I said in the beginning, this presentation is made by me in my capacity as Abdul Salam Waiswa, not as the head of legal. So if you have any concerns about this issue, Please do not blame my employer UCC, employ me, and I'll be happy to provide whatever clarification you might have on this issue. Once again, I thank the audience, and I hope there are some questions or even recommendations on how maybe this conversation can be taken further for the betterment of our workforce in Uganda, but also for improving the survival rates of our companies in this country. I thank you very much.
Okay, thank you so much, Doctor. We have had quite a very eye-opening presentation, and I think from the key takeaways from what we have had today is that we should not sweep the rights of employees under the rug. We shouldn't keep them in the dark when the company is going bad, because in most circumstances they may have the solutions to be able to usher this company through aspects to do with business rescue and so on. So we really thank Doctor for taking off time today from your very busy schedule to really brief us on how important it is for us to also focus on employees and how to deal with their contracts in the context of insolvency. So we are now going into a very, very interesting section or segment of today's presentation. We are going to have a panel discussion in a few minutes. And before we get to that, we have quite a number of questions in the chat. There are two questions from Victor Bitature. His first question is, Dr. Waiswa, thanks for the educative lecture. Can insolvency proceedings be brought against a government which fails to pay debts with when they fall due? In mind, I am taking cognizance of the scenarios where domestic and foreign debts owed in governments grow exponentially year in, year out. Thank you. That is our first question.
That's the first question. Under the insolvency, thank you very much, Mr. Bitature, for that question. People have asked me that question before, but under our insolvency law in Uganda, unfortunately, a government wouldn't be eligible for you to start insolvency proceedings against them. But I'm aware that in some countries, there are framework through which governments, local governments, can actually be declared insolvent. And that, for example, Greece is one of such countries, but also in the US, in some states, you can even declare that municipal authority bankrupt, and it has happened before. But in Uganda, the law it focuses on companies, individuals. We are a little tied by the law, but the concern is well noted. Okay. There is one asking for ULS to share the physical copies of the presentations. I think this will be shared to all participants. We are happy to share them with you for you to further improve your understanding, but also to give us recommendations on how best this can be done. Yes, someone is asking about Rocco, that these are his statements, not mine, that Rocco allegedly, I can add that word, the directors siphoned off some funds in some Swiss bank accounts, and then employees maybe were left unpaid. Could they have been helped if we had the same law as South Africa? Yes, certainly if we had a law like the one of South Africa, employees of Rocco and other companies in that state would be better protected. But also too, even with our current law, if Rocco had been put under a formal insolvency procedure, I'm not aware that a liquidation order was issued, though there was some attempt to place it under liquidation. But if the orders had been issued and the competent liquidator was engaged, then part of the mandate of a liquidator is to do what is called asset tracing. They can avoid transactions, they can order directors to refund money, they can even challenge any preferential payments that could have been made by this company to any other creditor over and above these other creditors who may not have been paid. So the Insolvency Act generally empowers the insolvency practitioners to do so many things for purposes of improving the value, the manner available for distribution to creditors. So it again comes back to who is appointed as a liquidator, how agile they are in managing the affairs of the company, and also interpreting the law to use it to compel the directors or any officers of the company who could have misappropriated funds. And the law allows any money is paid out unfairly 6 months before, or contracts entered into a year before the commencement of these proceedings can be avoided, and whatever money that could have been paid to such a person can be brought back into the pool for the benefit of everybody. All these processes are available, and even our law as it is has the procedures and processes on how those orders can be gotten. Maybe we've not tested enough some of these provisions, and that's why when we have these engagements, we call upon colleagues, the law society, the insolvency practitioners to venture more in trying out these provisions. We've had this law for the last 11 years, but some of these provisions have not been tested. So maybe we need to begin testing them in courts of law so we can have this law as a live instrument that supports business recovery, but also punishes people who misuse their positions in companies to defraud the community, suppliers, consumers, employees, and all other stakeholders. Thank you. I hope that answers that question.
Thank you so much, Doctor. We do not have any other questions in the chat, so I want to take this opportunity to really thank Doctor for taking us through this very critical aspect of insolvency practice in Uganda. And now we shall be advancing to the next item on our agenda, which is going to be a panel discussion between a number of distinguished insolvency practitioners in the region and outside the region. And they are going to be essentially talking about different opportunities within the insolvency space, both regional and international. For this panel discussion, it shall be moderated by Mr. Kenneth Akampuira. He is a founding and managing partner of Amber Solicitors and Advocates, formerly Kenneth Akampuira Advocates and Solicitors, with over 18 years experience as a lawyer. He is also an insolvency practitioner, and his major areas of practice include insolvency and restructuring, arbitration, commercial and corporate law, and construction law. He's a licensed insolvency practitioner. He's a member of the Chartered Institute of Arbitrators. He has worked on quite a number of financial and debt models for restructuring of delinquent facilities and companies. It is truly an honor to have him moderate this discussion, and as you are going to hear, there is quite a lot that our members in the region have to share with us, and at this juncture I would like to hand over to him to take us through this presentation. Kenneth, you're welcome. Over to you.
Thank you very much. It's an honor to be moderating this session where we have different players in our market and also in the region. I think something that is so beautiful about us is that insolvency, I think, is one of those cocktails that people always miss out. I call it a cocktail because of the various professions that are involved or that engage in insolvency. Under our Insolvency Act, we only permit 3 professions to act as insolvency practitioners. Under our section 2041 of the Insolvency Act, the first profession are the advocates or the lawyers, then the accountants, then chartered secretaries. So I'm honored to be joined with other professions who've logged in this morning to be able to participate in this brainstorming and very interesting topic in my view. I call it my marketplace because what we're going to be discussing today is sharing where we can make more bread, in my view, for the lawyers and all others who will be joining. So I'll introduce our panelists for the morning. I'll start with Mr. Donald Nyakairu. Mr. Donald Nyakairu is a senior practitioner in this jurisdiction, that is Uganda. and he's a partner at ENS Africa. I will dodge the long bio and say that he's a seasoned practitioner in Uganda, and I think even in the region per se. ENS, of course, is known for having roots in South Africa, so he will share both South African and Ugandan and also East African experiences. The other panelist for this morning is Malvi Chevda. I hope I got it right, Melvin. She's a partner, no, I beg your pardon. She's a senior manager at PwC, based in Kenya, and has over 14 years of experience in Kenya, Tanzania, Uganda, Zambia, and the UK in providing business advisory, executory, transaction advisory, and investigation services. By virtue, I think, of your employment at PwC, I believe you have audit, accounting, taxing experience. So we definitely have a very good resource when it comes to our cocktail this morning for the panel. The other panelist is Rogers Terry Turiasingura. Roger Terry Turiasingura is a senior legal consultant with Addison Global Office in Dubai and Abu Dhabi, and has over 7 years of experience in multi-jurisdictional transactions. Previously, he also worked with Legal Mark Advocates. We'll pick up his bio as well. He's a lawyer, I would say. Then we have none other than Kalu Okori. He's a partner at Punuk Attorney and Solicitors, heading the Insolvency and Business Restructuring Training Departments of the firm. I will be very clear that I'll not go through his bio, but will project it. But he comes highly experienced. I think one of those bios that I would want to have, I would say that he's a fellow of the Chartered Institute of Insol, and he practices in Nigeria. He's also done some work here locally in Uganda, and he definitely also carries some weight in terms of our paradigm in Uganda, how we practice our insolvency and the opportunities. I'm glad to be the moderator for this panel, and the topic is just quite exciting. Opportunities and strategies for thriving in insolvency. I think I'm one of the participants today who will be partaking, since I'm joined by the experts in the region. Straight away, I'll shoot. My dear panelists, I won't allow you to project your presentations, given the time that we've been given. We've only been given 1 hour. If I split our time within the 4 of us, it would mean that we will take 40 minutes, so we'll only have 20 minutes for a Q&A. And of course, plus some downtime of maybe 2-3 seconds of internet, since we're in Uganda. So fine, straight away I'll shoot, and I'll ask, who goes first? I'm rolling my dice, 2 seconds gone. Carl, I'll shoot to you first. Smile is an acceptance that you go first. I was about to go to Rogers, but since you have a smile, then I'll go with you. Kalu, can you kindly share with us the opportunities that insolvency practitioners have in Nigeria? In 5 minutes, I'll add you one more for my interjection.
Good morning, everyone, and thank you very much for the opportunity. And it's a pleasure to be among colleagues. On the market keeps expanding with regional treaties and all the rest, and so we look forward to more engagement in this type of engagement within ourselves. Opportunities for insolvency practice and for practitioners in Nigeria, I'm sure does not differ much from yours, in the sense that at the bottom of it all, whether in any jurisdiction, will simply be that the companies are facing challenges, and so you then have to look at how to apply the skills of professionals. You do have opportunities that will come in from the perspective of the paradigm for the company. Is the company going to trade, or is the company not going to trade? So, in other words, you have opportunities that lies in restructuring. If the company and the business will trade, and in a more mortician approach, if the issue is that there is no opportunity for trading for the company, and of course our insolvency law is to a large extent similar to Uganda in the sense that you have business rescue tools that are formal, and you also have liquidation tools that are formal, and you also have recognition of preventative tools that are both informal in terms of opportunities for workout, including with the assistance of the use of the powers of the courts to direct parties when they are already in litigation, or even without that. And so because of the time, I don't want to go into the details, but the insolvency framework, as effective from 2021, we have the CVA and the administration of insolvency options that we already had. Prior to that, you had receivership, stroke management, you had liquidation, whether voluntary or involuntary, and then you have the scheme of arrangement that you would use either for the purpose of in an insolvent context or in a solvent context. The new law essentially provided a more balanced regime, where even for the scheme of arrangement that used to exist without a moratorium, we now have an optional statutory moratorium for 6 months that can be entered into, which also insulates and protects the procedure from litigation, and gives a better, a chance for business rescue to occur. I saw that Kabito Karamagi did have an interesting presentation and case study. Formally, a statutory moratorium, and will give the opportunity for everyone to work. We do also have, under the new procedure of administration, we have post-commencement finance opportunities, which was not existing prior to that. And that is a lot of opportunities, both for the practitioners and also for financial advisors, and for distressed investors, and so on and so forth. And so it's a nascent market, and it has opened up opportunities which before now practitioners used to go to either the borrowing powers or the scheme of arrangement to try to bring in equity investors. But at least with the PCF approach, you can have more of the debt financing coming in. There are opportunities that we're having with the new framework, with the regulators, and with other special laws that have come in, where, for instance, to tackle the issue of Ponzi scheme, you have special laws, special capital market laws that allow the regulator to essentially appoint what you call administrators that also essentially would bring in their expertise in terms of insolvency to look into how to tackle with the menace of Ponzi scheme. One interesting thing as well that we can talk about is insolvency generally itself also offers an opportunity in specialized sectors. In many sectors, you have businesses that needs to be licensed in order for them to continue to trade. Going back to the issue that I raised, and the ability for an IP to work with the regulators and with the special laws to obtain, necessary buy-in for some of the restructuring plans is critical, because if you do not have the licensing or the approval of the regulator, you will not be able to achieve what you may want to do, even if you have the powers under the general law. Finally, I will just say that the choice of office, insolvency office, that the new law presents for us also impacts on the opportunities that you have. Somebody talked about asset tracing. I think Dr. Weiswa, I think the last presenter, talked about asset tracing, and particularly asset tracing and even going after third parties. Our new law, the old Office of Insolvency as a liquidator, presents greater opportunities, but that has a price, and that means that the business may not trade or may not come back to trading, even though the liquidator can convert later into an administration or a scheme. But the point here is that it's only under a liquidation that, for instance, you'll be able to go after the estates of directors that have allegedly siphoned, to use the word of the moderator, assets of the company. Thank you very much.
Thank you very much, Kalu, for your brief presentation. I'll come back to you on Ponzi schemes and asset tracing. Ponzi schemes, because in Uganda, I think we have many of those. But in the same, yeah. So in the same narrative, I think I'll ask. I think I'll try and balance my boat. I'll ask Chevda to also share her experience, or what she can share with us in terms of opportunities that we in the region can actually take advantage of as insolvency practitioners.
Sure, thank you. It's Maruti chapter. But so from a conference perspective, there's quite a large task in relation to insolvency related matters. The good thing is that a lot of the region has updated the insolvency legislation. I know Uganda's Insolvency Act is 2011. I think Kenya recently updated the insolvency legislation in 2015. We've seen similar updates in Zambia, and I understand Rwanda is in the process of updating the act. And the updated legislation offers more opportunities and more progressive opportunities. So rescue has become a key feature, like I mentioned, and the rescue regime also allows for better remedies and better outcomes for the parties involved. From the matters that we've dealt with here, there's a lot of room for collaboration between both legal practitioners and accountants in running an insolvency process or pre-insolvency advisory type engagements, restructuring that Kalu talked about. So some of the specific areas that we've worked with legal practitioners on. So for restructuring engagements, we usually advise our clients to enjoin legal practitioners in the early instances. Restructuring engagements will typically involve an analysis of what financial aspects need to be considered in the restructuring, and identifying a payment plan for the company that it will actually meet, a sensible payment plan that that is within the company needs. We also look at the operations and whether they need to be restructured, the, the restructuring plan that needs to be agreed with creditors. And while we look at the financial and practical aspects of how the restructuring will be achieved, we often partner with lawyers to draft the agreements and contracts between the borrower and the bank and any other third parties that need to be involved in making a restructuring successful. When we do we are typically called in as financial advisors and insolvency practitioners to review the options available for a lender where it's dealing with a non-performing debt. So in that context, we seek the advice of legal counsel to understand the options that the security documentation allows the insolvency practitioner to employ. I'll give you an example. In Kenya, the 2015 Insolvency Act introduced administrations as the procedure, as an insolvency procedure. But the administrations are not open to every borrower or every bank in relation to its different lending. There's special provisions that need to have been included in facility documents for the administration route to be possible. So getting legal advice to make sure that we get the right procedure, even if we do proceed with an insolvency, it's critical. It prevents legal change from borrowers who are grieved or suffered this presentation earlier on. The first step is usually to keep control of the business and its assets, doing a review to prepare proposals that are then voted on by a body of auditors, and then executing those proposals. In Kenya, we have a 12-month timeline within which, and we'll deal with a number of issues during that time. Employees are one. If the company is operational, then keeping operations running, that's also a major task. Dealing with the queries from interested parties. We've done a couple of listed company insolvencies here, and there's a lot of regulatory interest in how those insolvencies proceed. And all through that insolvency proceeding, we usually seek the input of legal advisors, from reviewing securities to providing ad hoc legal advice, dealing with litigation. Litigation is a very common feature in our insolvencies here in Kenya. Almost every matter we've dealt with has had a major litigation element. And then other aspects of getting involved in the sale process or in employee issues, contract negotiations. We've also sought the advice of legal practitioners in dealing with tax advice, our matters, conveyancing where we are sold assets, and when we have claims we are dealing with, that have an impact on the insolvency, then we usually get legal advice there. So from an accountant's perspective, there's also a lot to do apart from the day-to-day running of the business and stakeholder management. There's regular reporting requirements in respect of our insolvency work, and running a sale process of the assets, due diligence by the buyers, and facilitating that. It's quite a busy time. I mean, in the past, our receiverships have for many reasons, either due to litigation, just delaying selling the assets, then a very long time. Even our administrations, which normally are supposed to run 12 months, they can be extended with the leave of court if the proposals are not fully executed. So I guess another important point, sometimes people don't planning at least 12 months usually to execute, depending on the complexity of the asset. Sometimes we have a record receivership that lasted 17 years here. Perhaps there are others that have lasted longer. So lots of opportunities for work. There's the jobs are very evolving and very complex. So they require a lot of input from different parties. We also work with SMEs a lot. So subject matter experts. If we are dealing with a cement company, we'll take the input of a cement sector expert in executing our mandate. I'll stop there in case there's any questions or if just thinking from the other members.
Thank you very much, Malvi. I allowed you an extra 2 minutes because you spoke into an area where many of us would want to tap into in terms of business. Our topic is business oriented. Serve for your panel in Uganda at PwC. Do you also ask our regulator to share with you our list of licensed insolvency practitioners? Say yes or no.
Yes, of course we would.
Okay, fine. I speak for the lawyers who are on the platform because we are thirsty to receive instructions from PwC and we've not received any. So I wanted a confirmation that actually our list is with you as a senior manager and you have it. So I'm glad to hear that the answer is a yes. I'll straight away.
Yes, we've worked with some of you in the past.
Thank you very much.
Thanks.
So we look forward to receiving more. So please take note of the names that are that have logged on. If you see any familiar one, kindly feel free to forward instructions. We have over 100 advocates, with the exception of Kul, of course. Okay, I'll shoot straight away to Rogers. Rogers, you have the opportunity to also help us, the Ugandans and others who've logged in, on how we can tap into the Abu Dhabi market. We have a good cocktail of our representatives everywhere in the world. So since you're on that side, kindly share with us opportunities. 5-6 minutes.
Thank you very much, Kenneth. I'm also a Ugandan, so I'm one of those Ugandans looking for the opportunities, I guess. Thank you to the organizers of the conference and Team Diplomat for organizing this. So I'll just dive deep into it. The GCC generally and the UAE, as I said, for the UAE, we have about 5 insolvency jurisdictions in one country. So you will have about 2, which is Dubai International Financial Center and the Abu Dhabi Global Markets that are common law based as jurisdictions in insolvency, and then you have the different emirates with their mainland insolvency regime. Now, in terms of what makes the difference in how insolvency is here and how I used to see insolvency back home, and I've seen improvement towards that, the difference really is on technology and compliance in this tech-based system. So you will find that they make compliance very easy. In Dubai International Financial Center, for example, someone who owns a company, director of the company, is able to go through their portal, and then through the portal are able to appoint insolvency practitioner or liquidator in this case, and then this liquidator is appointed just through an email, no letter, nothing. The person is able to do it very seamlessly, and then response is given, and everything is done like that. But also the system has been made in such a way, because of Sharia laws and Islamic financing and things like that, you find that the financial institutions are not easily into they don't want to enforce very fast, because there are many things around Sharia you share in the losses and things like that around Islamic finance. But I will just talk mostly about technology, and I wanted to just borrow a quote from John Jerry. If you know John Jerry, he was in Notel and in Enron, and there's a recent FTX bankruptcy that happened. So John Jerry says, I have 40 years of legal and structuring experience, but never in my career have I seen a complete failure of corporate controls and an absence of our understanding of technology. Technology is ahead of all of us, the practitioners, the regulators, and the judiciary. Now, I'll just give you a few stats of an INSO report that was recently released in 2019. It says only 35% of the responders said that they had used technology-assisted review. And then obviously only 43% are aware of how to use it, and only 7% are actively using it. Now, for the opportunities, the actual opportunities are in the technology space, insolvency and technology, there's a nexus. Because when an insolvency practitioner takes over, I've seen it in the recent case here, where they took over, well, I'll just say a money exchange business that involved a lot of Ponzi-related scams. But the sheer volume of the material that had to be looked at, if there was no technology-assisted review involved, it will take so long. And that's why I think insolvencies take so long. So in this market, I've seen that people have accepted technology, compliance involves technology, and I've seen data analysts are now accepted as insolvency practitioners, where in our jurisdiction we only have typically a lawyer, an accountant, and that's it. So you have a forensic analyst also accepted as an insolvency practitioner. You have the special regimes for green finance, and I think that's another area we borrow from. So you'll find that most of this green finance that is coming up, a lot of the agreements demand a special regime for how they do the insolvency. And in this market, I've seen people go into green finance related insolvency, because that is where the money is right now, and that is where insolvency will be. One of the other things I've seen is cryptocurrencies. Of course, now we have the biggest cryptocurrency related bankruptcy that is taking place. So it is something someone should look at. Now, insolvency mediation is another area. I've seen that people specialize in it here, and it's something we could pick up. Crisis management specialists. As you know, when insolvency happens in a crisis situation, now one of the things that they first do here is beyond when you are appointed as a liquidator, they ask you, do you have crisis management experience? Now, the specialists in this area have been able to do so well around that. So I think it's something that we could also pick. And I think finally, the other one I've seen is white hat hackers. These are ethical hackers, and these are acceptable in only Abu Dhabi global markets and Ras Al Khaimah economic zone. A white hat hacker is, of course, the hackers are generally bad people, but a white hat hacker is the ethical hacker. And the white hat hackers have been able to help with forensic investigations where you have cryptocurrencies breaking into those cryptocurrency wallets and things like that, because you find that you cannot trace the assets. So you need a white hat hacker to trace these assets, the crypto assets and things like that. So I've seen white hat hackers also have an opportunity there. So I think we could pick from that cocktail, and then from crisis management to the tech space to green finance and so much more. For especially the younger ones who are able to take it on, because the numbers show that insolvency practitioners from the INSO report, you see that insolvency practitioners are way behind. And as John Jen said, I mean, he has over 40 years experience, and he says he has never seen something like that. Technology is ahead of all of us, the practitioners, the judiciary, and so we need to prioritize. So I think those are my contributions.
Thank you very much, Rogers. You have definitely opened a new can of worms in my view. You're now talking about insolvency of companies or entities that are dealing in non-tangible assets, cryptocurrency, that is quite unique. So when I get back to you, please prepare to tell us how actually an insolvency can, especially in terms of stock taking, how do we take stock of cryptocurrency if it is crashing? How do we take stock of the assets of Alibaba? All those that are online based, where there is no store, there is no known address, like plot 1 Lumumba Avenue, everything is online, and you're the insolvency practitioner, and your job is to find the assets of such an entity. You've touched a bit about the forensic aspect, but we'll come back on how a Ugandan insolvency practitioner can actually do a proper good job on identifying assets, especially since they could fly out in the air with a crashing or even just internet. I'll now go to none other than, in Uganda he would be called a senior counsel, Donald Nyakeiru, with your vast experience as MD, head legal for one of the biggest communication entities. I think you would definitely have some windows that you can open us to look into as insolvency practitioners. This time I won't say the young insolvency practitioners, because I think insolvency is quite old in Uganda, but young in terms of a practice, because all of us are looking for the same opportunities, whether big or small or medium practitioner.
Thank you, Kenneth. Thank you, participants. Thank you to the organizers. I think the Kenneth going last has sort of crippled me a bit, but I'll do the best I can because most of the opportunities I had, I thought I would outline have been mentioned, but I'll elaborate on them too. I think there's a policy shift, and internationally, away from pure insolvency, liquidating and closing down the company, and more shift towards business rescue. And I think in Uganda, we've tried. I participated in some business rescue efforts as an insolvency practitioner. Some have succeeded, some have failed, some are ongoing. But as an opportunity, I think as the economy grows and as more companies go into business, I think the projection is that the Ugandan economy is growing by about 5.3%. More businesses will come into the country, and more foreigners will also invest in the country. And at the same time, the businesses, because business is tough, more businesses are facing significant financial challenges, and therefore there will be great demand for insolvency practitioners. And as has been outlined by my colleagues, the face of the insolvency practitioner has changed. It's not purely a legal practitioners in that sense. You need accountants, you need technology experts, you need a whole array of experts, crisis management experts, as was mentioned. And I think as lawyers, we need to equip ourselves better and get into niche areas where we can become experts, so rather than being jacks of all trades. And I think the opportunities are vast. We did touch, my colleague, I think Rogers, touched on crypto assets and crypto farm insolvencies. That's a big area in itself. And you can't believe it, but in Uganda, there are some, although the regulations do not allow it, there are some companies carrying out crypto trading. And some of them have actually had problems. These Ponzi schemes you hear of, they're all around crypto assets. And so we've got to get into that area, understand it, and specialize in it in order it's a very vast opportunity. Around technology, I think Rogers gave another side of technology. I want to give another side of technology. We have in this country what we call payment systems. These are companies who are now licensed by Bank of Uganda. You will have seen that now you can go to a shop with your card, tap a machine, and your payment will be made. There is a company behind that. There's a company that provides that point of sale machines. There's a company that provides the software, and all of them in one day are likely to have financial problems. And those are opportunities. Those are opportunities in this market. There are many payment systems operators in this market, payment systems providers. I think that's an opportunity. One has got to understand the business. I think as lawyers, I think we need to get into these companies and understand how they operate before they get into financial trouble. You need to, for example, let's say a telecom company, you need as lawyers to try and get a secondment into the company, even for free, to understand how a telecom operation is handled, how the business is run, and this will assist you in future. There are several companies, telecom companies, which have collapsed here. If you had been an expert in that field, I think that's an opportunity that you would have touched upon and been able to drive along with. There is equipping yourself. I don't know how many of you read the reports of the Bank of Uganda. Those reports issued by Bank of Uganda give you a lot of information about what's happening in the market. They give you information as the likelihood of companies failing, non-performing loans, etc. I think those are publications which you should acquaint yourself with and keep on top of what's happening in the market. Across border insolvency, many companies now have branches in Uganda, in Kenya, in Tanzania, and Rwanda, in South Africa, in Mauritius, and one has got to look at that as a very big opportunity. When a company collapses, let's say in Kenya, it has an effect on the Ugandan company. You're called in as an insolvency practitioner in the Ugandan company. Now you've got to understand what's happening in the region, what's happening in Kenya, what's happening in Tanzania. That's an opportunity available to us. The aspect of asset tracing was touched upon. I think right now we are involved in some insolvencies where we are doing asset tracing, and we are also capable of doing forensic audits. There are opportunities in this market. You see companies, I can probably say, it's a game collapse. Do you know what's happened? What type of insolvency did you go through? Were you able to establish whether they paid all their employees? Are you able to establish whether they siphoned off some money out and bought villas, let's say, in Paris? Those are opportunities which we can get into and thrive. But it needs dedication, and as Malvi mentioned, lawyers cannot do it alone. They need accountants, they need other experts. We have a team, forensic experts, ex-police, bankers, all bunched up together. And if you have the team, you're able to get into these opportunities. There's also opportunities in the litigation space. ADR in insolvency, that's a very big thing. And on its own, a litigation of that sort can even go on for 10 years. And as a lawyer, I think you're looking for fees. That's a great fee opportunity. I think those are the current opportunities I see in the market, and I hope we'll be able to identify more. Thank you.
Thank you very much, Don. Going last, I think you went well, in my view. You went last, but went well because you painted a broader picture again. And before just I take leave of you and I go back maybe to Melville or Rogers or Kalu, you've mentioned reviewing Bank of Uganda reports. Those are financial reports really on websites, in Tanzania and Kenya as well. And I want to read in between the lines. As a lawyer, what would I be looking out for? Because there's a lot to read on those websites. The reports are reading indices of the drop in the dollar, the shoot in the shilling, the fragile market of the financial sector, banks are closing. What are you looking out for? Just walk us in the park.
Yeah, you're looking for so many things. You're looking at the state of the economy in which you operate in. You're also looking at the bigger level, the economy of the region, because they also touch the economies of Kenya, the economies of Tanzania, what's happening in Rwanda, and what's happening worldwide. You're looking at what's happening, the effect of Ukraine, the Ukraine war on Uganda. That is information which you need to know whether these companies which are operating in Uganda are going to survive. You might have investors here from Ukraine, you might have investors from Russia. I think you need to look out from those reports what might happen to them. You need to look at the global economic outlook. Is the world economy growing? And it is growing by 3% according to recent records. You also look at what's happening with the non-performing loans. What are the ratios? Are the loans growing? If they are growing, that's an opportunity. There must be some companies which are going to close or which are in financial problems. And that information you pick up and you analyze with other information from elsewhere, of course, and then you're good to go. And you're informing yourself of opportunities which you'll be able to get into when the right time arrives. Thank you.
Thank you very much, Don, for at least opening our eyes and walking us through the park, knowing at least what we can look out for. Melville, do you have anything to add, since you're also a numbers person? Malvi?
Yeah, me apart from you, are you able to hear me? Can you hear what I'm saying?
Yes, Malvi, yes.
Yes, Malvi, we can hear you.
All right, yeah. So I was saying we also look at central bank reports here, just to get a sense of the economic climate, to get an idea of what fiscal policy is going to be in the future, and to talk, to get a better understanding of the aspects that Donald covered. Apart from that, we look at the corporate environment generally here. We have some sectors where we've seen systemic distress, not only in Kenya but across various reasons.
Malvi, I think we've lost you in those last sentences. I think we've lost you.
Or the specific ones where we anticipate based on published results or some other market intel that there's an issue. We track sectors that are distressed. So during COVID, for example, we were looking at the hospitality sector. There's other matters we dealt with where we've seen multiple companies in a particular industry being affected by either global changes in raw material prices, for example, or regulatory changes closer to home. So looking at financial information, and then we get queries from different parties. So a recent trend we've observed is multinationals kind of redeploying capital. So exiting certain markets where the performance is not as they expected, and
Melvi, I think we've lost you.
redeploying into new markets. There's no pattern in how it's being done. Know what
I've been hearing that very
drop
well.
off and log in again.
Malvi, I think we are losing you.
Whether the problem is isolated to I alone. Can you
Yeah,
hear
I think
me?
the problem is on your side.
Exactly, because we can hear her very well.
Oh, okay, fine. Then it's on my side. Okay. Okay, fine. I think we're now good. We're now good. Melvi, can you just come back a bit, just 2 minutes back from your presentation, from your reaction? Okay.
Yeah, I'll proceed. I hope the rest of the attendees can hear. So I was saying that we track the stress sectors either where there's a change because of government regulation or where there's a global trend. Cement sector is a great example. We've dealt with so many cement-related matters in East Africa, and a lot of the distress in the cement sector here was occasioned by first overinvestment by existing players, and then second, dependence on imported raw materials, where raw material prices then increased. So it's as Donald was saying, to be a student of the world and the global economy and the direction it's going in, and then apply it to your local context and just be aware of how businesses in the market are doing.
Thank you very much, Malvi. I just want to run to Kalu. In Uganda, we've had many construction companies having challenges in terms of going insolvent or having challenges with capital, finishing projects and ending up in insolvency, with very many creditors running around chasing for unpaid bills in terms of material by suppliers, those that have supplied on the building sites. Are you having the same in Nigeria as well? Is it a sector issue that's now construction, or there are other areas where we might be heading to, and as Uganda we can expect something going in another sector, maybe the telecoms?
Well, the short answer is not particularly restricted to the construction industry. We do have construction, we have telecoms, we have the manufacturing sector as well, where you have some of these issues being prevalent. And in the new law, we've had the definition of critical supplier, and in an administration, the ranking and priority would differ because of the business rescue approach, and an administrator is entitled to, give some preference to critical suppliers to be able to save the business. But at the same time, the definition has been a bit narrow under the new law, and basically utility service providers are those that are targeted. But it has been a case of half bread is better than none for us because some of these issues are not that entrenched. And so we are also amending as we go. The insolvency regulation are also trying to balance that. In April 2022, we've had an insolvency regulation coming in. What practitioners would do, which I have done in an administration that I'm doing, is to obtain under the directive orders of the court to obtain the leave to pay, out of priority, out of ranking for certain critical suppliers, so that one would be able to be in a position to actually achieve a better chance at business rescue. One of the other issues that I quickly want to mention, which Malvi touched on, is in the area of collaboration. I think it's important to stress that issue a lot for us practitioners, particularly in the jurisdiction where we are in East Africa and Nigeria. We have started with a territorial approach philosophy, a very strong one at that, in the African jurisdiction. And the world, of course, has gone global, as Rogers has been able to show us that we are chasing technology. And transactions are both ethereal, intangibles, and across borders. And so it's very important to understand that technology is key. One of the most important things for any practitioner to do now, particularly if you are dealing with asset tracing or you are dealing with the ability to source for information so that you can properly map out a plan on time, is the use of technology, as has been said. And for you to obviously be able to do that, you would have to have consultants in IT, consultants in technology, including in cryptocurrency. Those are expensive, but those are very vital, particularly for those businesses that are intangible. The other issue is that in the first place, if your business rescue may actually be, for instance, if you are looking at a sale of the business, because the business in the first place is based on intangibles, you will need to actually find candidates that are in the same business and that have the technical know-how in terms of the use of technology to be able to extract a value for the business. And typically, for instance, in the capital market, where you have a lot of clientele portfolio, things that are being done in terms of intermediated securities, in terms of clientele portfolio. If you are not able to deal with the regulators and to deal with finding licensed firms that will be able to take over, you are more likely to proceed to a liquidation, and there will be a lot of losses, and also it becomes a risk in terms of the industry itself. Sorry, I regressed a bit, but I found some of the contributions interesting, and I wanted to just give a perspective from Nigeria.
Thank you very much for your perspective. We really do appreciate, because it looks like we share a lot in terms of our practice, Nigeria and Uganda. You touched about ADR together with Donald. You talked about alternative dispute resolution, and I would want to ask Rogers, because Roger also came out very strongly on ADR as an opportunity for insolvency practitioners to take advantage of, especially those in this jurisdiction. Can you share with us your experience in Dubai and the AEE on ADR, how it's used as an alternative dispute resolution mechanism for insolvency matters? Rogers, kindly unmute.
Sorry.
Okay.
So about 2 or 3 jurisdictions here have a robust ADR framework. That is the Dubai International Financial Center, ABGM, and Russell Khan Economic Zone. The rest, in the mainland, the Sharia law applies, so you don't. The ADR is largely between families and things like that. But in these other places where the ADR system is robust, what I've seen is that you have insolvency practitioners already in their own. We already have an insolvency practitioners board in ADIFC, okay? And that insolvency practitioners board encourages, when you're writing the preliminary report as an insolvency practitioner, one of the things you must show is how far have you gone with ADI. So ADI is usually the first, it's a requirement how are you trying on the ADR in your preliminary report, which you give in about 2 months. So they make it almost compulsory for all these insolvency practitioners to try as much as possible to mediate and see how this can be done. And it is not as if they force you, but you can see that you must report about it. So ADR is really important, and I've seen results from it. Given chance, most of the time, some of these disputes are really resolved. And because everyone is in distress, so when they find a middle ground, they are happy to do it. And with DIFC, they make sure that in your preliminary reports, you say how far ADR has gone and how you used it, and if it is able to achieve, in your view, the desired goal. Yeah, thank you.
Thank you very much, Rogers. I think you've supplemented Kalu's earlier presentation of half a loaf is better than none. So I think there's a temperament that people must adopt as insolvency practitioners from your presentation and that of Kalu, and plus Donald as well, that you should be able to allow certain things to not to have your full claim, but you can have a few head cuts here and there, some head cuts. I don't know whether members on the platform, those that have logged in, are actually embracing the ADR, because given our nature of our practice, we love the combat. We love the uniform very much. So in fact, I'm very happy on the presentation that at least we have Kalu. Kalu at least is not putting on a tie, but the rest of us are suited, ready for battle. Yeah, fine. I want to run back to Donald. Donald, what's your take on ADR? How does one take advantage of ADR, or how do I jump into this opportunity of a dispute? I don't want to behave like a coffin maker, but there's a dispute that has arisen during the insolvency in terms of claims, which one should go first. As an onlooker, maybe I have read the papers and I've seen that there's an insolvency going down. How do I position myself as an ADR expert to help the parties?
Well, I think you can position yourself in many ways. I think the first one is at the beginning of the insolvency. Let's say you are handling a provisional administration, for example, and you're in there to try and rescue the business, although our law gives it a very short period. But you're dealing with various parties. You're dealing with creditors, you're dealing with shareholders, you're dealing with directors, you're dealing with all sorts of, you're dealing with employees. Now, I think this is where you have to enter into some alternative dispute resolution mechanism, because there you have competing interests, different interests. Everyone is thinking differently. The creditors are thinking differently. The employees are thinking differently. So that is when you get in and try and bring all the parties together to come to some administration deed, which can allow go forward. Because if you go the other way and cases are brought after when you leave provisional administration, the company will just collapse. So it's a mechanism which will allow the business to continue in the interest of all the parties. But you have to have a particular skill to handle that resolution mechanism. Thank you.
Thank you very much, Donald. I'll set this one up. I'm going to set you up, Kalu, unfortunately, for a surprise. Kalu, there is an application for a company going into administration. The cause list shows that the matter is coming up at 9, and you represent no one, but you're in court. I don't want to say that you're an ambulance chaser or that you're trying to ambulance chase, but how do you get instructions in a matter where
Instructions from who?
there are parties who have not disclosed their interest. You're an alternative dispute resolution practitioner, either a mediator or you're an arbitrator, and you're in court. And the judge is trying to understand how this administration would go, since there are parties in court and they've brought their application. Set up.
Okay, interesting question. You know, by our rules of professional conduct, you can't just go out there and be advertising yourself.
The disclaimer was very clear. No ambulance chasing.
That may not apply to an insolvency practitioner per se. However, wisdom is profitable to direct. One of the things that we have in Nigeria is that we've been able to make sure that insolvency is regulated. Under our constitution in Nigeria, professions are supposed to be regulated by laws. And so with the new law, you have an area of regulation, and we do have recognized professional bodies that are entitled to train, and when people are certified or trained and have a certificate or are admitted as members, they would be able to apply to a license as an insolvency practitioner. So BRIPAN, Business Recovery and Insolvency Practitioners Association of Nigeria, is one of that. Incidentally, I'm General Secretary, I'm a fellow as well. Of course, it's already known that I'm an insolvency practitioner, and I do write often on insolvent issues. The courts now do have a tendency of also recognizing some of the practitioners in the industry for their expertise, or at least for their contribution. So I'm likely going to be in a position where, under the guise of being what we call an amicus curiae, which is a friend of the court, maybe to make certain remarks to intervene, and of course you take it on the queue and maybe offer some recommendation to the court as an amicus curiae, and point out as well that insolvency being a regulated area, and in this type of situation where it is a collective process, it may be important for the courts to look at perhaps making sure that fair hearing is provided, because I'm also a litigator, and that it would be good for certain orders for certain parties to be put on notice is given by the court, to avoid a situation where orders may be given hurriedly and be set aside and put the judge in a precarious position. Hopefully, by doing that, I would be in the good books of the judge, and the court has a power to give directions, even for normal litigation, for somebody to be called upon to give services, even though it's in the criminal area. And so the court may want to ask me as General Secretary to make recommendation, or also maybe to say, okay, he or she would like to hear, the professional talk a bit about this situation and what they think should be done. And hopefully as well, for some of the people that are in court, then that may mean that, this person seems to know what he's doing, and we see how it goes. I hope that answers your question.
Kalu, I must say, excellent, excellent, excellent. If I were the head of the bar in Uganda, I think I'd grant you a practicing certificate. Just come across and start. But unfortunately, those powers are not with me. But excellent. Thank you very much for at least giving us the insights on how a Nigerian would do it in our courts. Yeah, so
don't worry very much.
yeah, because amicus curiae was not envisioned in my mind even, that actually you could apply as amicus curiae, but you pulled it off. Thank you very much. I want to go to parting shots now because I think I have 10 minutes to go. Malvi, what's your last word to a Ugandan practitioner on how they can take advantage of their practicing certificate as insolvency practitioners? How they position themselves? We are looking for business market.
Sure. I think advice would be that people should keep their eyes open for opportunities, and where there's not an immediate skill available, then seek that skill. Partner with.
Melvi, I think we didn't get you on that one. I'll give you 1 minute to just recap. I think it's on our side.
Keeping your record.
Melvi, we lost you on our side. Just 1 more minute, just to recap for us on your submission. I think on our side we lost you.
Okay, I was just saying it's important to have a good track record. The experience people have when they work with you, and your ability to achieve the originally envisioned objectives. Those aspects are very important, and repeat business is the way to go. So
thank you very much,
that's
Melvi. Thank you very much.
my
Donald?
Yes, thank you. I think the first thing is I don't know how many have these certificates. I think the first thing is to get that certificate, because I see some questions here about how does one get the certificate. I think that's the first thing. Not many have registered. The second one is I think the opportunity is in writing articles. As Kalu has said, you need to begin a culture of writing articles. You have very many opportunities of channeling out those articles and to be known in the insolvency space. And that will market you and for free. The third one would be develop capacity. And develop capacity, team up with the likes of PwC, and when you get that job, you will already have a team. Develop a team of forensic experts, develop a team of investigators, develop mechanisms of asset tracing, and not asset tracing only in Uganda, because most of these people who set up companies to defraud others in country have various schemes in Malta, in Gibraltar, in Mauritius, in South Africa. So you've got to be able to have a team that can do asset tracing. I've seen that it's very important, and sometimes it's financed. That capacity is financed, and they will be able to pay you for that work in advance. Then develop negotiating skills and read widely. I think Insol also has a number of podcasts on their website. I think it's an opportunity to listen to those podcasts because they give a worldwide view of what is happening in the insolvency world, and they give you tips on how you can develop yourself further. Thank you.
Thank you very much, Don. Can I hear from Rogers?
Thank you again, Kenneth. So I'll try to, as much as possible, to speak to the younger demographic of this platform. So I think there's opportunities really. First of all, in networks and creating collaboration. It does not have to be you employing these people for whatever the case may be. It could be just having networks, such that because they come into play, and this must be interdisciplinary. It could be someone who's chemical engineering. It doesn't matter. They come into play. And then, of course, knowledge. There are many free courses, coaching and training, leadership, ethics, which is very important for insolvency practitioners, financial management. Most of the time, lawyers always say, "No, leave that to the accountants," but they will still have to come to you explaining the accounts, so you have to be able to learn that. Human resource management is also key. Crisis management, as I mentioned earlier. These are courses that are available, and I think we should take advantage of them. Specialize as much as possible. Insolvency alone is wide. There could be also opportunities to specialize within insolvency. You could just be someone who deals in a particular, insolvency of MSMEs or insolvency of, NGOs or whatever it is. So find a niche within the insolvency cluster. Then finally, I think attend as many trainings as you can. It's also important. Mediation, there's space, and just the digital tools that are available for you. You could monetize what they call influencing. I think it's becoming more, digital influencers, it's becoming very commonplace, and you could also choose to monetize your content. It could be written content and things like that. So yeah, that should be it for me.
Thank you very much, Rogers. Before I go to Kalu, when you talk of influencing, the only influencing I know are those who influence for bars and cocktails. Give it a perspective on legal.
No, I think several social media platforms that are professional in nature. LinkedIn in itself is now monetized. You could monetize your work that you publish on LinkedIn. Even Twitter in itself is now paying people who release content for as long as you have enough traffic on the content that you release.
Kalu, your parting word of wisdom?
I think Rogers covered the field excellently. I think what I just want to emphasize is, you mentioned two things. Maybe that's a similarity, and that comes from what I said is the philosophy of our insolvency laws before the reforms that have come in. You have to change your mindset. You have to change your mentality. Nobody can change it for you. And as a man thinketh, so he is. So that also applies to your practice. If you have the mindset of a debt recovery person, you will never innovate. You will never look at the values that are in the business. It takes a lot to build a business. Yes, there will be challenges around the life cycle. The human resources are the greatest assets. They are also the greatest liabilities. But you have to be the one to bring out the value. And so, like you said, maybe if you remove your tie, you'll be a bit more relaxed, and you try to look at how to deal with the issues rather than being belligerent. By our training, maybe for many of us that are lawyers, and like advocacy, you just want to have a good fight. That's good, but there are more ways to create value for yourself and for different stakeholders, and insolvency gives that opportunity, because that's why it's a collective debt resolution tool. It is not an individual debt resolution tool, and you come into an environment that has different stakeholders, and I can see that you have a session coming on negotiations and stakeholders management. And so it's very important to have that approach. The last point is understand that insolvency is not a selfish practice. Collaborations are key. For you to be successful, you need to have, like Malvi says, you need to have lawyers, you need to have accountants, you need to have forensic persons, and you cannot know it all. And really, there are different sectors that are very specialized, and so you then also have to be a manager, not just of a business, but of the process, and of being able to assemble a team that will help you in being successful. And these collaborations usually would be interesting because you already have networks, this law society, insolvency associations. So referrals and all the rest will come. And as they say, one good turn deserves another. Bearing any issue of conflict of interest, usually you will get other business referral from other professionals that you may have worked with. Thank you very much.
Thank you very much, Kalu. I think the takeaways are quite enormous in my view. We have picked at least the first one, being synergies between practitioners, our cocktail of accountants, risk managers, mediators, technology experts, forensic auditors. I think we've picked at least one big root, not even a leaf, from your last presentation, that it's important to synergize as opposed to keeping it in your boxing ring. So more fighters, more players, better result. I will now hand over to Paul, who's been moderating since morning, to handle our Q&A question, if there are any. And I think he also has a few questions to put to us, I think, as the moderator and also the panelists. Thank you. Paul?
Okay. Thank you, Kenneth. Thank you so much, our panelists who have taken off time off their busy schedules to really address us on key opportunities within the insolvency space. Indeed, we have taken note of these opportunities and we are going to try our level best to leverage on these opportunities to further advance insolvency practice in Uganda. Okay. So we do have a few questions, some raised from amongst the practitioners in Uganda and some from within the team. And Malvi, this goes to you. We just want to know, how has the Kenyan regulator been able to position insolvency practitioners or the practice of insolvency in Kenya, especially in light of the advancements that are being made in AFTA? We know AFTA is going to open up opportunities for so many people, but is there a fear that insolvency practitioners may be left behind, or are there some deliberate efforts being taken by the regulator to ensure that we really spread our wings and fly beyond the borders together with those in AFTA? That's a question I would extend to Malvi. Yes.
Sure, thank you. From the regulatory perspective, as I mentioned, our law is quite new. So 2015 was when it was first enacted, and since then there have been a number of steps to make it more practical, more usable in daily insolvency practice. There have been engagements through our regulator with our tax authority to make insolvency guidelines clearer from a tax perspective for practitioners. There have been other consultation and aspects of the law are not clear, and clarity is required to help people make the right decision on the ground day to day, and to help the courts also adjudicate matters correctly, leaving no room for misinterpretation. Our regulator, I don't think, is dealing with specific issues of, AFTA is an example. I mean, dealing with that on its own, I don't think that is a key aspect for our regulator to look into. Our regulator looks at insolvency practice more generally, not in relation to specific changes in other pieces of legislation. Where we look, and from my experience in engaging with the regulator, where the focus has been in the past is in making sure that the practitioners, so in licensing, for example, making sure that practitioners who are licensed are operating within the expectations of the insolvency regime, and then in clarifying matters where there is some room for misinterpretation. And then finally, dealing with the issues that insolvency practitioners face. So, like Carl was mentioning, we also have our our insolvency association here. We call it ATIC, it's the Association of Turnaround and Insolvency in Kenya. And through engagements with insolvency practitioners at ATIC, there's been an opportunity for our regulator to understand on a day-to-day basis what are the challenges insolvency practitioners are facing. And what can be done to enhance both regulation and more practical guidelines or aspects that can help improve how the profession is conducted here, and make insolvency proceedings reach their conclusion faster. The challenges, I think, generally with insolvency proceedings that last too long are that the cost build up and the value reduces. So our insolvency regulations and regulator, I think, is focusing on addressing those aspects, not necessarily dealing with specific pieces of legislation that are amended or raised. I know I haven't fully answered your question, but I hope that was helpful. Each view I don't get.
You most certainly have. At least my key takeaway from your answer to my question is that this is largely a responsibility for the insolvency associations of each of the countries involved, and I think that really speaks to us as members of the association we are part of in Uganda to really be very proactive when it comes to seeking out these opportunities, especially in light of AFTA. So thank you so much for that. I do have a question for Donald, but I think this is more. I'm just throwing it out for us to really have a discussion on drawing the perfect balance between alternative dispute resolution and insolvency proceedings. We are really aware that these insolvency proceedings are more of a collective recovery for the general body of creditors. And when you look at alternative dispute resolution, it seems to be an inter-party dispute resolution mechanism and also has its specific timelines. So how do you preserve the balance between the objectives of an insolvency proceeding being collective, having a bit of flexibility in how you handle different rights, and how do you balance the interests on one side with the expectations of alternative dispute resolution? That's a question I'm directing to Donald, but please feel free to.
Yes. Yes, of course, insolvency is a collective debt collection mechanism. But here you're looking at preservation of value. I think that is how you sell it to the creditors. You're trying to preserve value. You have to show them that if you just go straight into whatever process, administration or liquidation, you must be trying to preserve value. And you must show them that if we end up in a liquidation, you're not going to get anything out of it. So you'd rather now deal with the company that is in trouble, the shareholders or the directors and management, and try and get the company back in business, operating fully. Otherwise, they are going to end up with nothing. I think that's where you've got to give them that alternative, and whatever disputes they might have, they must work towards putting back the company into business and moving forward, rather than just going for debt collection, and that would be the end of it. I think we have to move away from debt collection and more into rescuing the business. I hope I've answered your question.
Yes, Donald, you most certainly have. Thank you so much for that. I do have a question for Rogers as well. Earlier on in your presentation, you did mention that most of the insolvency proceedings in the UAE are governed in compliance with Sharia law. And I would like to understand how most of the countries that have adopted the ancestral model law on cross-border insolvency seem to have a different way of or a different structure when it comes to handling cross-border insolvency. So how do we draw the balance between tapping into opportunities that may arrive in the UAE when this side was sort of we are seeing a shift towards adoption of procedures under the model law. Where do we draw the how are we able to preserve that balance? Is there a case maybe that has been handled in a jurisdiction where such a balance has been drawn that we can draw lessons from?
Paul, thank you very much. So again, as I said, we have about 4 to 5 jurisdictions here. Now, recognition of foreign judgments is automatic in 2 jurisdictions that are common law, DIFC and ADGM. Now, when it comes to the mainland, which I said is a mix of Sharia and civil, there is no automatic recognition. So you have to apply for recognition under the mainland courts, depending on the Emirates. If it's Dubai, then the Dubai courts or Abu Dhabi and things like that. But we have not had a lot of cases where what people have been doing is to have automatic recognition in DIFC and ADGM and then use that to enforce on the mainland. Because it is very complex to try to have recognition in the mainland courts, obviously because of language barrier and the difference in laws. So that is what people have been doing. You apply for recognition in a common law jurisdiction as DIFC or ADGM and then subsequently enforce on the mainland. That has been the route people have been using. But they've been adopting in a piecemeal way. There's a British, because the British have an arrangement, a bilateral agreement with the UAE, their judgments are almost automatically recognized here. But for the other countries, we have seen not so much traction around the world. Yeah.
Thank you so much for that, Roger. That has really at least thrown some light on how the cross-border practice should be done when it comes to the UAE. We've taken note of the fact that at least there are some practices that are being adopted in some of the jurisdictions, and we can hope to draw some more lessons from you in the future. We hope to see you in in some of the INSOL reports as one of the as one of the key practitioners that is advancing the call for more. Last but not least, I do have a question for Kalu. We would like to know how asset tracing has been successful in Nigeria. We know it's one of the very key practices in insolvency in Nigeria, and we just want to draw some lessons and opportunities for us in Uganda and what we can really apply to our jurisdiction that has been successful in Nigeria.
Okay, thank you very much. First, asset tracing is challenging anywhere. However, obviously in countries where you have a very high level of access to technology, and of course the market in terms of technology is very high. Rogers has mentioned Dubai and all that, AI and being able to use and analyze data is a bit better. Typically there are issues in relation to privilege information, confidentiality with respect to data, financial data with the banks, and so you typically need interim orders from the court to assist you where you don't have the alternative of being able to access email data and other electronic data which you have to study. Within that context, and it is a bit of a catch-22 thing, because also to get interim orders from the court, you have to be able to establish some level of prima facie case that you have good information. So it takes you back to the quality of information and your ability as a practitioner to source for information. One of the key stakeholders are usually employees. In a business review, when they do see that basically you hopefully would preserve their jobs or their rights in terms of being preferential creditors, they are more likely to cooperate with you. We do have challenges which comes, like I said, from the general background that we have in terms of our insolvency law. There's a lot of recalcitrant attitude from the debtor, the directors, the members, and as Malvi mentioned, Nigeria, most of our businesses are SMEs, and so the business is quite tied to the personalities of the debtor in possession. So on a good day, we need to have a change of even legal culture and have more options for a debtor in possession approach, which the US has. And the introductions of tools like the CDA actually are a bit more helpful, and the administration, when it can be initiated by the debtor. In that way, you have some level of success in terms of time maximization and information. But if that doesn't work, well, like I said, you have to rely on electronic forensic activities, and you have to rely on court orders to push things forward.
Thank you so
Well,
much.
I'm being successful at the moment in a very big administration. Though it took time, but in the last 1 month, I have hit the jackpot. I can say that very well in terms of email data and things of that sort. And we have a team that is reviewing. Creditors are also coming everywhere. I have a judge that is very proactive, that understands the issue. And judges wear two caps. From the perspective of administration, there is an administrative part, and the judge is your supervisor. An administrator is an officer of the court. Again, with the law, most of the insolvency office are obligated to act as officers of the court, apart from being agent of the company. And so when you're able to have a good working relationship with the judge and basically carry the judge along in terms of capacity building, and also getting the judge to understand that you are basically doing the work as being subject to the court and an officer of the court, and you're able to have, because there are two levels. As a judge, he will sit for the litigious matters. But as a supervisor, the administrative issues are conversations that need to be had, and some information that you have may be privileged or so sensitive that you cannot bring it up in the open, particularly in terms of asset tracing. Our insolvency regulations have pointed out that there are two situations where you would not have to give full disclosure of information. One is if it will endanger the life of any stakeholder, and second is if it will jeopardize the successful administration of the insolvent procedure. And so when you are able to do that and you have a judge that is proactive, it's fantastic. And I must say that in one of the most recent one we are doing, we have a judge that is very proactive, and it has helped. We've been able to use the investigative powers as for private examinations for different people to get substantial information. So yes, the success is available, but it requires also collaboration with different critical stakeholders.
Thank you so much, Kalu, for really emphasizing the need for us to work within the ecosystem that we have, and to ensure that each member of the insolvency ecosystem is collaborating with one another to really achieve the intended end. Well, with that, to our panelists and to our listeners, we come to the end to day one of the Insolvency Conference. I want to thank the members and our panelists for sitting through what we had to present today. I want to thank each and every presenter for taking off time to really come up with very interesting subjects and topics that are going to benefit the wider group of insolvency practitioners in Uganda. And as we break off, I just want to remind us that we shall be back here tomorrow to talk about quite a number of key issues. Let me just check in here. We'll be back tomorrow at 9 in the morning. We'll start with a presentation on navigating insolvency, effective stakeholder management for successful resolution. We'll also be navigating the intersection between insolvency and taxation. We all know as insolvency practitioners that taxation is a very critical issue in our practice. So we'll be having a speaker to take us through that, specifically to advance strategies for financial stability and compliance when dealing with insolvency. And then we shall have a presentation on reporting and accounting in insolvency proceedings, where we shall be focusing on the principles of transparency, compliance, and stakeholder protection. This is what we'll be having tomorrow. So with this, I want to wish you all a good lunch, and for the rest of the day, Godspeed. Thank you. Thank you. Thank you, sir.
Mm-hmm.